The present petition for maintenance, which was raised, has been dismissed. As it is observed that the grounds which have been taken in the election petition may be heard and finally disposed of, along with the main petition. That's why the petition for maintenance, which was filed for declaring that the petition is not maintainable, is dismissed.
Madam. My lord, in main my lord election petition, madam.
It is, I don't know where it's going.
Written statement, everything filed, my lord. The next step is, my lord, the issue and documentation.
Documented issues, no?
My lord, documentation.
Your Lordship, I may be granted to file an IA for striking out some irrelevant documents herein. There are some documents which are irrelevant and that will
who filed those documents?
The opposite party.
Irrelevant, that is
there is a procedure, there is an option, there is apex court judgment wherein in election petition, if irrelevant documents are taken up, which can cause a hindrance for quick disposal of the election petition. So there is a provision for filing as such.
It's up to you, but the question is that maybe Supreme Court, I won't disagree with you, but the question is that if these are their documents,
exactly.
They have relied some documents on the basis of which they are trying to say that the election process was whatever, the election was not done. So if you say that there are some irrelevant documents, you may be at liberty. I don't know exactly that provision is not so much I'm acquainted with.
This is
liberty, but the otherwise we are facing. Cannot give you any time for interlocutor application. You may file. That is up to you.
Yes.
But in the main case, most probably it is just at this stage you have already filed your written objection, written statement.
Yes.
So issues are already been.
Not yet, ma'am.
Not draft issues are not.
It's not yet, ma'am. As I said, the draft.
And the main application you just write on order. And Mr. M. Katul, counsel for the petitioner, election petitioner, and also heard Mr.
R. Rakshap.
R. Rakshap, sir. R. Rakshap, the learned counsel for the respondent. From the record, it is seen that the pleadings are already completed. Accordingly, both the parties are hereby directed to file their draft issues, if any, along with the documents. List accordingly when it can be listed.
Since this is documentation and issue and documentation, so may I phrase that, madam, on 26 or 7, madam?
Let it be on Your Lordship, let it be on April, since it will be too early. This is an election matter, so let it be on 22nd April, Your Lordship.
Madam, that will be too long, madam.
Long because it's the election petition. So
11th April in that case.
Madam, 11.
Don't make it on 11th April because from 12th most probably holiday will start. So that too, I'm just telling it because up to 11th April I have my bench from from the principal seat.
Yes.
So through VC we have to hear. So don't keep it on 11. Make it on 9, 10, whatever you want.
Yes, 9. Let it be on
9 of April.
Diploma.
And simply it is for the filing of the draft issues and documentation. So it will be, it's not, it will not be problem.
Longer date is required.
And if we, in the meantime, if you want,
yes,
that your filing of I is necessary, you can.
Yes, absolutely. Deeply obliged.
For means only one IA. In IA 231.
Yes, sir. 231.
231. Rest will be listed according. तो बाकी जो है उसको उनके साथ लिस्ट करना है तो वो बोल देगा जैसे हमारा चाहिए सब लोग को बोल देगा बाकी होगा लिस्टिंग वो उसको मालूम है उसको बोल देगा. So now this your execution of this judgment and award dated 19/10/2024 and the consequential award passed by the learned additional district and Session Judge. The reference case number 2/2024 is stay, subject to condition of the payment of 50% of the enhanced amount. But the condition is that the deposit shall be made before the registry, Guwahati High Court, Itanagar Permanent Bench, and same shall be kept in a fixed deposit by the registry to secure the justice. No order of withdrawal and disbursement is passed at this stage. If it is there, then you can very well approach before this court. Because 50%, I have just considered the amount, 50% of the enhanced.
50, but 50% would be too high here.
Yes, it will be around, it may be around 200 crores or something like that. 50% of the enhanced amount, around.
Yes.
So it is quite a big amount, so you file the order, subsequent order may be passed accordingly. Otherwise, it is stayed.
Fine, my lord. Normally, my lord, it's in the reference code that the deposit is normally made, my lord.
I thought better it to be here at a fixed deposit, we'll see to it.
My lord.
For signature.
Hey, you know.
3 and 4 जो है उसको शब्दों को बोल के रखा है good details. She knows. Yes.
I'm going to mention item number 17. Your Lordship here, according to law, we're supposed to take the step. Accordingly, we have taken the step, but due to technical error, it could not be completed. So, Your Lordship, I humbly pray that also.
Technical error, how it come? Technical error.
Due to the mistake in the case number, Your Lordship.
So it was not sent.
Yeah.
URMS?
B memo.
MS B Meva, the learned counsel for the petitioner, and it is submitted that in person to order by this court. The petitioner had already taken steps, but due to some technical irregularity, the steps could not be sent. Accordingly, prayed some more time to take fresh steps in proper and correct address with proper and correct details. Prayer allowed. Take steps within 5 days. This matter accordingly after 3 weeks will be.
Mayor, my lordship, I beg to mention item number 15 on behalf of Mr. S. Tapin. This matter will be listed after 2 weeks, my lordship. He is out of station.
Estapin is out of station.
Consent has.
Mr. Patin is also here for the opposite party. Have you taken consent? So when do you want to fix it?
After 2 weeks.
After. Mr. Estapin. Okay, well, listing it after 2 weeks. Otherwise, it's a case of 2018. Still in order column. I don't know why. Yes.
So I beg to mention item number 23
23.
on behalf of the petitioner.
So RF for hearing, na?
Yes.
You are for the petitioner,
Petitioner.
appellant. What was the difficulty?
The leading counsel out of station.
Who, Mr. Jamu?
B. Jamu.
So we are listing it after 2 weeks, as it is a old pending.
3
case.
weeks.
3 weeks, they need after 3 weeks.
Last.
Yeah, Your Honor. My lord, I would mention item number 25.
Mr. Dole, we have passed the order, in fact. We have passed the order. You are not
Application
audible
was
also.
wrong. Yes, my lord.
Yes, I have not, this one, the 50% is obviously passed the order of, but the order of disbursement and the withdrawal is not yet passed. And the registry is directed to make a fixed deposit to secure the interest of this case.
Obliged, my lord. Obliged.
Lordship, I beg to mention item number 25.
25.
On behalf of R. Sonar, R. Sonar, respondent. He's out of station, Your Honor, conducting counsel.
Have you taken consent of?
Yes, Your Honor, we have taken the consent from the opposite party also.
Rajesh Sonar is out of station. List after 3 weeks. Okay.
3 weeks may be given, Your Honor.
3 weeks it will.
Obliged.
Was there any interim due? No. 1825. Was there any interim? Just show me the record. It is otherwise this is supplementary hearing this. Whatever is done. The interim order shall be continued previous day. Yes.
I forgot to mention, I have a 17, here is an entry. 20 continue.
In item number 17. Item number 17, interim be continued.
Yeah, please. They are agreed by the impugn of the matter by which matter the delay of condemnation has been allowed. And,
Allowed?
yes, madam. 51 days in days in filing
51
connected,
days delay was conducted.
madam. But to me, my lord, as per my quotation, madam, the respondent herein, they were not the necessary party in the village level proceedings, madam. Now, my lord, by this appeal, civil appeal, by filing connected, my lord, the miscase for condemnation of delay of 51 days, my lord, in process. My lord, they are going to create another, my lord, the forum, another, my lord, the rights and titles over my peaceful position of lands. My lord, who were, my lord, not necessary party in the village level proceeding has been allowed by the, my lord, the landed court below by condoning the delay of 21 days, my lord, in filing civil appeal, my lord.
No, there was a village.
Yes, ma'am.
Ah.
Village, my lord, initially, my lord, what happened? Complaint was lodged by some group of people against me, my lord. And kebab was conducted, my lord. Village proceedings, my lord. Now this days, my lord, as per the, my lord, the AP Civil Court Act, the village authorities are customary court. Accordingly, my lord, the village level customary court was conducted and held, my lord, decided in my favor, my lord. The parties to the proceedings were, my lord, agreed the decisions of the village authorities. They are not, my lord, preparing any appeal against the decisions of the village authorities, my lord. But, my lord, here the respondent who are, my lord, who were not necessary party in the village level proceedings, my lord, they prepared an appeal by filing, my lord, the condemnation petition as well as, my lord, civil appeal, my lord. So therefore, my lord, if they are at all
Appeal
agreed,
preferred now, this appeal is pending before which court?
my lord, Civil Judge Senior Division, Alo, Western District, my lord. So therefore, my lord, by that way, my lord, they cannot, my lord, they create another, my lord, forum to claim over my land. If they are at all, my lord, agreed by the, my lord, decisions of the village authorities or the, my lord, they are not at all agreed by the decisions of the village authorities. My lord, they are claiming the rights and titles over the land which was in my possession. Then, my lord, my lord, that way, my lord, if he is at all, my lord, he agree, then, my lord, he can go for the kebab and other, my lord, the proceedings, my lord.
No,
Yes,
but the
but-
question is that against you, there was a complaint.
Yes,
And on that basis was Keba was there or village proceeding was there?
correct, ma'am.
That was in your favor.
Yes, ma'am.
And you're saying that against that order, if they are agreed, they could have approached the appeal forum, but they have not done. They have directly preferred an appeal.
No, madam, they were not the necessary, not the party in the village kebab proceedings, ma'am.
Who filed this an appeal?
Yes, ma'am.
They were not the party.
Not the party, ma'am.
In
Now they are claiming that-
original Keba proceeding, they were not the party.
No, madam, yes. The party who were complained in the village level proceedings, madam, they agreed, madam, they put their signatures, they are, madam, ready to comply with the decisions of the village authorities, madam. Now, madam, these respondents who are responding in this, madam, the instant civil revision petition, all of a sudden they came, madam, started claiming lands and madam, the claiming rights and titles over my land, saying that the village authority has wrongly passed an order that land belongs to me, madam. Madam, my suggestion, madam, what I'm submitting is, madam, if they are at all agreed by the, madam, my position, rights and titles of, over the land, they could have initiated another the proceeding from the beginning or go for the civil suit, but not by way of this the appeal.
So now that appeal which which they have preferred is
Yes.
against the order of this village
Village.
proceeding.
Yes, exactly. So therefore, that this is notice may go, and the meantime, this maybe the notice may suspend for time being. In the meantime, notice may issue.
The notice will go and what is your interim prayer otherwise?
Yes, my interim period is for stay of the impugn order, Impugn order is lordship at page number, page number 10. Oh, sorry, I'm sorry, and except 10, page number 165,
Page number 165.
correct, madam. The parties who were not, the respondents who were not parties in the proceedings, they, in mid of the way, they entered in the proceedings and they started claiming my land. This is the impugn order,
Whereby the appeal was entertained by condoning delay of 21
Correct,
days. So your entire CRP is based on against this order only.
Yes, madam. And I've stated in grounds of appeal by way of this by court civil appeal before the learned court below, they cannot period another rights and title over the land. If they are at all aggrieved, they could have initiated, they could have exhausted the provisions under the same AP code or the civil procedure code. So that is the whole condition, not by way of this the appeal before the learned court below.
So how it will help you with by staying this order?
The proceedings will be not help furthermore. Unless
Then don't go by the interlocutory order. You can make a prayer for stay of the further proceeding of the civil appeal itself. I think.
Madam, once this lordship interfered this proceedings, they so till that they have not admitted the appeal, civil appeal. This is only condonation, madam.
But as soon as the condonation was allowed, suppose, by that time most probably appeal is already admitted, I think, or
No, madam.
generally admits.
The appeal is not yet admitted, madam.
Not yet admitted.
Not yet. This was order passed on 11 February 2025, madam.
Pardon, Mr. M. Kati, to manage counsel for the petition. This is an application that is eligible against the order that is so and so. Issue notice to the respondents to Mr. AD and as usual process. And also call for the second copy of the DCR. Mr. Katu, the learned counsel for the petition, but is submitted that the present respondents is not at all has no locus standi to file the appeal. Appeal is number civil appeal number 04. No?
04.
Locus standi
Of
to file the
2024.
civil appeal number 04 of 2024, which is pending before the Learned Civil Judge Senior Division, West Siam, Alo, Arunachal AP. As the respondents were not made party in the village proceeding against which village proceeding and against the order passed by the state village proceeding, they had approached the civil forum. He further submitted that on the basis of the complaint, there was a keva of the village proceeding wherein the order was passed in the favor of the present petition, and the respondents were the party to the said proceeding also agreed to the said order. However, without having any locus standi, the present respondents preferred an appeal against the order of the village proceeding, wherein they claimed the right title interest over the disputed land. Mr. Kato further submitted that if they have any claim over the property, right title of the property, they could have approached any village proceeding as well as any civil forum, but they cannot prefer an appeal against the order of the village proceeding wherein they were not the parties. Next point, Mr. Kato accordingly submitted that on the basis of their application filed under section 5 of the Limitation Act, the 21 days delay in preferring the appeal has already been condoned by order dated 11/2/2025. Accordingly, he prayed for stay of the order dated 11/2/2025 till the disposal of the present petition. Next paragraph, considering the entire facts and circumstances of this case, the order passed by the Learned Civil Judge Senior Division by CM Miss case number 22/2024 and has been out of civil appeal number 04/2024 is hereby stayed till next date of festival. Just accordingly after 3 weeks.
Right. Deep level.
May I please, my lord? My lord, this civil revision petitions filed for challenging the legality and validity of the order dated 17/2/25 being passed by the Learned Civil Judge Senior Division at UPI, my lord. My lord, before I'm taking into the order dated 17/2, I'll just brief back of the case, my lord. Here in the case is that, my lord, since 2021, I have paid sum of rupees 11 lakhs to the respondent, sole respondent herein, for consideration of plot of land, my lord. Since she wanted to sell her plot of land for dire need of money. So accordingly, as a relatives, as a friend, I paid her sum of rupees 11 lakhs in two installment, my lord. On 16/8/2021, I paid her sum of rupees 10 lakhs, and 9/7/2020, I paid her 1 lakhs, and altogether 11 lakhs. So thereafter, when she shown me that plot of land, which she apprised me that that plot was not fit for human settlement, and it was slough and hilly areas. So I rejected the plot, and I approached her to return my money, which I have paid to her. So she agreed that she will refund my money, or either she will show me other plot of land money. So accordingly, I given her time to refund my money, or either she has to show me another plot of land money. So what happened, my lord, on 24/10/2021, I went to her house for asking for refund of my money, along with some of my family and relatives. Just I have discussion with her, and what happened in the evening, she launched me FIR against me before concerned Limu police station, and case was registered under section 448, house trespass, my lord. So thereafter, our relation was not good, my lord. So what happened, my lord? Thereafter, again, I have served one legal notice to my legal counsel for refund of my money, but she didn't repay my money. So thereafter, I compelled to file money shoot, my lord, before Civil Judge Senior Division at UPI on 6/8/2024. So in that time, my lord, it was already delay of 49 days, my lord. So accordingly, I have filed one IA for condemnation of delay under section 5 of Limitation Act. In fact, it is not applicable in money shoot, my lord, but I have just to show the learned trial court the condemnation limitation being extended by the Honorable Supreme Court in show motto writ petition number 3/2020, my lord.
So that was for a period, I think.
Yes, my lord.
So we're covering the COVID period.
Yes, my lord.
So now your case is.
My lord, my
That
money
is
was Honorable Supreme Court has, my lord, given exclude the limitation, my lord.
Yes, obviously, but that is for a particular period, in fact.
Yes, my lord.
So where your case covers that period also.
My lord, my money was given on 2021, and Honorable Supreme has excluded that period, my lord, in show motto cognizance, my lord.
Yes, there is an order.
Yes, my lord. So, my lord, thereafter, I have placed that order before the London Civil Justice Senior Division, but it was not considered, my lord. So that is the case.
So now this case, my lord, this impugn order dated 17 February 25, my lord. The learned civil judge has not considered and not excluded the limitation being given by the Honorable Supreme Court.
Where is the order?
Lordship, it's page number 52 to 52 to 53, my lord. May I read out, my lord? Just operative portion, my lord. Page number 52, my lord. Just fourth para, my lord. Learned counsel for the applicant relied in, just I read out, my lord. Learned counsel for the applicant relied in the judgment of Honorable Supreme Court in recognizance for extension of limitation order dated 10/1/22 and submitted that the period from 15/3/2020 till 28/2/22 is excluded, and therefore instant case comes within the period of limitations. On the other hand, learned counsel for the respondent has next page, my lord, submitted that the judgment in para number 2, it is submitted that the exemption granted during the COVID period from 15/3/2022 28 February 2022, while order dated 23/3/2020 was brought to in while order dated 8/3/21, and which was effected only during COVID pandemics. Third, both the learned counsel and pursued the application and written submission also pursued the provision under Section 5 of Limitation Act. Section 5 of Limitation Act provides that that any appeal or application other than an application under Order 21 of CPC may be admitted after prescribed period if applicant or the applicant satisfied the court that he had sufficient cause for not preparing the appeal and making the application within such period. On partial of the provision of Section 5 of Limitation Act, it is evident that the said provision applies only to the appeal or any application and would not apply to an application filed in connection with the suit for delay conviction. Further, on partial of the judgment referred by the parties, it is seen that extension of limitation was given during the period of COVID-19 pandemics, and the court has been functioning regularly for post-pandemic since more than 2.5 years, and therefore the provision of the aforesaid judgment is not applicable now. In the view of the all above, the prayer and the instant application praying for delay condition filing the instant money suit number 4124 is hereby rejected. This is the order, my lord. So, my lord, as per my understanding, my lord, as per Supreme Court, Honorable Supreme Court direction, my lord, my money was given on 21/16/8/21, and then Honorable Supreme Court has given my lord, here that respondents only relayed the order dated 3/8/3/21, but Honorable Supreme was further thereafter extended, my lord. It was last order was passed on, my lord, 10 January 2022. In paragraph number 5, my lord, operative paragraph, my lord, paragraph 5 subclause. May I read out the paragraph, my lord? Paragraph 5. Taking into consideration the argument advanced by the learned counsel and the impact of the issue of the virus on public health and adversaries faced by litigation in prevailing conditions, we deem it appropriate to dispose of the MA number 21 of 22 with following directions. The order dated 23/03/2020 is restored, and in continuation of the subsequent order dated 8/3/2021, 27/4/21, 23/09/21, it is directed that the period from 15/3/2020 till 28/2/22 shall stand excluded for the purpose of limitation as be prescribed under any general or special laws in respect of all judicial or quasi-judicial proceedings. Paragraph number 2, my lord. Consequently, the balance period of limitation remaining as on 3/10/2021, if any, shall become available with effect from 01/03/2022. In case where a limitation would have expired during the period between 15/3/2020 till 28/2/22, notwithstanding the actual balance period of limitation remaining, all persons shall have a limitation period of 90 days from 01/03/2022. In the event the actual balance period of limitation remaining with effect from 01/03/2022 is greater than 90 days, that longer period shall apply. It is further clarified that the period from 15/03/2020 till 28/02/22 shall also stand excluded in computing the period prescribed under Section 33, subclause 4 and 29A of the Arbitration and Conciliation Act 1996. Section 12A of the Commercial Courts Act 2015 and provision B and C of Section 130 of Negotiable Instrument Act 1881 and any other laws which prescribe periods of limitation for instituting proceedings, outer limits within which the court or tribunal can condone delay and termination of proceedings. My lord, as per my understanding, my money was taken in 2021. So here, as per direction of this honorable apex court, that 2015 March, 15 March 2020, 22, 28 March 2020, it has excluded by the honorable apex court. So my limitation start from 1 March 2022, my lord. So 1 March 2022, if I taken count from 1 March 2022, during the time of filing my money suit, it was 2 years, 5 months, 5 days only, my lord. So limitation was not required, my lord. That is my prayer, my lord.
So I suppose it is not proper. Because period of limitation for 5/3/2020 till 28/2/2020 was excluded.
Yes, my lord.
That during that period, if someone fails to submit any application for condonation or file any
Yes.
case, that period will be automatically condoned. But your matter is of 2021.
Yes.
So obviously from 21 to up to 23 for 3 years limitation for the money.
Yes, yes.
So you'll get the chance up to 2024. But you remain silent and you're just calculating again from 2022 to 25. It's not proper, I think. It will, may not be. So we just, will pass the order on, not to stay for any order,
My lord.
but will issue the notice.
Yes.
Let us see. But
Yes.
otherwise, though, I don't think.
So my lord, yes, my lord,
any-
notice may be issued to respondent.
Yes, we are issuing notice. Let us see if any clarification is there in that case. we'll
Yes,
issue it.
yes, ma'am.
Okay. Heartily to go. Mr. Andrama, in counsel for the petition. This is an application, the section so and so in connection with so and so against the order of so and so. Yeah, the asset taken, you've been ordered it of 17/2/2025. And otherwise also,
Yes.
as soon as your, this, I mean, your limitation, condition limitation has been disposed of or rejected, suppose.
Yes, rejected.
So your money suit, which was filed earlier, it's not in existence. I
No,
get
not
that.
been existent, my lord, yes. After
So
rejection of,
against that order of interlocutory application, have you approached or have you filed any misappeal or any?
no, not been filed, my lord. So my prayer is, my lord, after set aside the order data 17/2/22 being passed by the civil judge senior division. So thereafter, my money should may be restored. That is my prayer. ma'am.
That is your.
Yes, ma'am.
Issue notice to the respondents to register DD and as usual process. Also call for the scan copy of the DCR. List accordingly after 3 weeks will do.
Yes, ma'am.
List after 3 weeks.
Much. Well, here, the petitioner is agree about impugn Gava Parwana, my lord, dated
Order
1/3/2025.
1.
1/3/2025. What happened, my lord? Gava was held, my lord, on 24/10/2024. My lord, we find it in annexure 4, my lord, page 46.
Page 46.
Yes. There was a Gava, my lord. And translated copy is in page 49, my lord. In this Gava, my lord, Gava was held for 2 days, my lord. Married, my lord. After hearing all the parties, examining documents, evidence, and witness, Gava has decided that Sri Karsan was alone for case against army in the court from side of army quarter. No one from land parties are able to produce document to show fighting case against army. They only produce versus document. Sri Hokalolan, by anticipating that area will be grabbed by army, issues some NOCs to Karsan Lolan. It was decided and passed that the parcel land in back side of army quarters should not be claimed by Karsan Lolan from the land owners who have purchased the land. The Gava passed that the land located in front of army quarter shall remain with Karsan Lolan. An area of 3.7 acre shall be kept for Sri Karsan Lolan as per NOC issued by Sri Hokalolan. Gava passed that land parcels in back side of army quarters shall be given to land purchaser. On clarification given by Sri Gunsen Lolan that the disputed land does not fall under the PDBR FTBC law, therefore Gava passed that this is clearly a private land. Here, PDBR, ATDC cannot make any claim. Regarding complaint lodged by Sri Dolukami, Kaba held that Sri Dolukami has not produced any witness and documents today due to which it cannot be decided in today's court whether Kami land is existed in disputed land or not. In future, if anyone wants to pursue the dispute, that can be done in between them. All the government members after the NOC issued by refer the NOC issued by Sri Ogalolan, AJB Dego, to Sri Karsanolin and passed that the plot located at front of Army quarter claimed by Sri Karsanolin is genuine and it is Karsanolin's land. For those plots located at backside of Army quarter, Kaba passed that Sri Karsanolin should keep available space for 3 floor vehicular movement. Sri Karsanolin should keep downside road clear. Sri Karsanolin should give 5 meters for downside road. Roads should be kept like Army quarter line in straight. In the event of dismantling of Army quarter, Sri Karsanolin should give 5 meters. Here, my lord, Kaba declared that the disputed land is petitioner's land, my lord, and he should give 5 meters of space for the road.
For vehicle flow.
Thereafter, my lord, the respondent number 1, 2, and 3, my lord, they have filed application before all West Siang District Gaubura Association. My lord, we find in Annexure 5, page 51. For review of Kaba dated 24/10/2022.
Respondent 1, 2, and 3.
Yes,
50. What is the page number?
51.
No, 51 is the Keba decision translated copy.
No, my lord, it's page 51, my lord.
I don't know. 51 is here. In my case, 51 is a translated copy of Keba decision. I'm just holding
It
this.
should be the same. Page,
Oh, what's I say? Just a second, just a second.
Annexure 5, my lord. Page 51.
Ah, yes, 51.
Pursuant to this complaint, application, my lord, first, Kaba Parwana was issued, my lord. It is in next page, my lord, page
The
52.
appeal was filed before whom?
Before all West Siang District Gaubura Association.
Respondent number 1, 2, and 3 had filed this appeal or application before all West Siang Gambara Association.
Yes, my lord. Before President, all West Siang District Gaubura Association. Pursuant to this, my lord, Kaba Parwana dated 11/11/2024 was issued, my lord. Annexure 5A, page 52, my lord. By which Kaba was fixed on 19/11/2024. 19/11/2024, but Kaba was postponed, my lord, as per request of.
Initially, Keba was fixed on 19.
Yes, 19/11/2024.
Then it was postponed.
Yes, postponed on request of petitioner, ma'am. In the meanwhile, my lord, respondent number 5 and 6, they have also filed complaint, ma'am. It's in page 54, Annexure 5P, ma'am. Before the Gaubura Association. Annexure 5P, page 54. Doing something, my lord. And respondent number 4 also filed, my lord. Application, my lord, it's in Annexure 5C, page 56.
57.
56. This was also filed before the President, all West Siang District Gaubura Association, for inclusion of his name as one of the complainants. Thereafter, my lord, after clubbing all the complaints, my lord, again, second Parwana was issued, my lord. It's in page 58, my lord, Annexure 5, 11/12/2024. Whereby Kaba was fixed on 4/1/2025. For interpolace territorial customary court, my lord, for trial of the defendant.
When it was fixed, then for 4-5, 4-1.
Yes, 4/1/2025. This was also not held, petitioner has requested, my lord, Kaba was postponed.
So now you are agreed by which order?
I'm coming to that, my lord. After that, my lord, this again Parwana was issued, my lord. 8/10
8/1/2025.
From the same.
Same. So, my lord, I agree with Constitution of Customary Court, my lord, interplace territorial customary court. I have filed representation, my lord. My lord will file it in page 66, annexer 6A, my lord. May I read, my lord? Page 66, my lord.
Hmm.
With reference to your Parwana dated 8/1/2020, calling for district inter-level customary cover on 5/2/2025 from your good office for hearing and execution of a filed by one Mr. Bunkonosi and others against the decision of customary court of Assembly where I have been with as respondent. Would like to state and submit that as per APCC Act, Arunachal Pradesh Civil Code Act 2020, the district affects territorial interpolice customary court, whatsoever the name it is. The said customary court is established and recognized, but the competent authority government of AP has not yet appointed the presiding officer who should preside the customary court. Hence, as a layman, it is understood that no appointment constitution of presiding officer Galpuras is done by competent authority. Under such circumstances, if any decision is taken from your office, there will be legal complications regarding jurisdiction and authority, and parties in the matter will take the ground and challenge the decision. As a result, any decision will have no meaning and imparting justice. As thus, my presence in the Sabha is worthless, and being so, I may not be attending the said Sabha customary court session until there is proper appointment of presiding officer. After that, my lord, this Gaonpura Association has issued order dated 3/2/2025, whereby Sabha dated 5/2/2022 was kept it against. My lord, you will find in page annexer 6B, page 67, translated copy is in page 68. Page 68, may I read that? For trial land dispute, an appeal was filed before interplace customary court for convening of the bar, and for which first Parwana was issued on 11/11/2024. Second Parwana was issued on 11/12/2002, but first and second Parwana was intervened by Sri Kartan by submitting application. Therefore, third Parwana was issued on 8/1/2025, fixing the bar on 5/2/2000. That too was intervened by Kartan by submitting application dated procedures for cancellation of the bar. In Sri Kartan cancellation letter, raised legal complication point. Therefore, Prabha dated 5/2/2025 is kept in evidence. This was kept in evidence, but again, they have issued this impugn Parwana date. Is in page 69, annexer 7. 1/3/2025. This is the impugn. By which, from which I am engaged. Translated copy is in page 71. In continuation of Parwana dated 8 January 2025, this Parwana is issued in your against Sri Gunganusi and 6 other complaint for Kayam Land for that in Parwana was issued on 8 January 2025, fixing Prabha 5/2/2025. That was intervened by you by submitting application and for raising legal complication point. Prabha was kept in against for some time by the order certain. Therefore, to settle the dispute, this Parwana is issued in continuation of earlier Parwana on and Prabha is fixed on 17/3/2024. By this Parwana, my lord, Prabha has been fixed, my lord, on 17/3/2025. I am, my lord, challenging legality and validity of this Parwana, my lord. On the ground that, my lord, firstly, my lord, under 1945 regulation.
So why don't you file any writ petition regarding if you have challenged the legality, validity of this paper on the subsequent sending of Parwana by the Gaonpura Association, or otherwise also jurisdictional issues you have raised. So you have not approached any writ forum. Why?
I have come directly before this.
Because you have challenged already. So you could have filed because you could have approached a writ jurisdiction then in that case. You have challenged all these things because the representation or the presiding officer not yet appointed, they had no authority. So such kind of things you have brought already.
Malad, I am filed this civil petition, my lord, because my lord,
this Gaupura Association.
Whatever, that,
They have
that
no
is very
authority.
challenge, that's what I'm saying. We have challenged their authority, the order of the legality, sending the Parwana, etc. is not legal, or they may not have the jurisdiction. So instead of coming up filing a CRP, you have not approached any read forum.
Yes, I have not opposed.
Why?
By filing this CRP matter, my grievance is 20 matter, that's my. That's
So
why.
what is your prayer?
My prayer is that, under 1945 regulation, there is no quorum for,
Oh, that will be
Gaupura
decided
Association.
later, yes, then now.
and other ground is that, under section 15, subsection 4 of Arunachal Pradesh Civil Claim Amendment Act, an appeal from village authority lies before inter village territorial customary court only if agreed by party. Only if agreed by party. And hearing this case, my lord, I have not given any consent, my lord.
So what is your interim prayer now? You want to stay?
My lord, for suspension of this impugned Parwana. My lord, there is provision of section 15. My lord, is number 3, my lord. After paragraph 2, my lord. After the fourth provision to subsection 3 of section 15, the following subsection shall be inserted. An appeal from the village authority, if agreed by parties, my lord, here, if agreed by parties, shall lie before the inter-village territorial customary court or apex customary court, by whatsoever name called, which shall settle the case as per local tradition. So, my lord, by this subsection, my lord, party has to agree. And in the recent case, I have not gave any consent. In fact, I have, by filing representation dated, I have objected, my lord. Representation dated 1/2/2025. I have objected the constitution of this government.
Okay. You are Mr.
LNOC.
Hard Mr. LOC. And NOC, the learning counsel for the petitioner. Item number 7. This is an application under section so and so against so and so. We can take it over. Mr. Lucy, the learned counsel for the petition submitted in this regard that on 1/3/2025. No. Your KEBA was earlier KEBA was dated 1/3/25. No, 24/10.
The 24th.
That one KEBA was held on 24/10/2024. Wherein the present petitioner was also a respondent, and accordingly the order was passed in KEBA decision, and thereafter directing the present petitioner to wherein your first order on KEBA was in which page?
First order of the
49, na?
yes,
49.
first order of the 11/11/2024.
No.
Okay,
KEBA decision was 24/10.
yes.
24, wherein the rights of the present petitioner over the disputed land was accepted. However, he was directed to give some spaces for free flow of the vehicular movement, etc. Subsequently, against the said KEBA order, the respondent number 1, 2, and 3 had approached the town village,
All West Siang District Government.
all West Siang District Gambra Association, wherein the Parwana was also issued to the present petitioner, asking him to appear before the authority on 19/11/2024. But on the prayer made by the present petition that has been postponed. But subsequently, the respondent number, again by the respondent number 5 and 6 filed another application before the said authority. And thereafter, another application was also filed by the respondent number 4 before the same village authority. So, and in all these applications, the parwana were issued. However, subsequently, all these applications were clubbed together, and one parwana was again issued on 4/1/2025, asking the present petitioner to appear on 4/1/2025, but on the prayer made by the present petitioner, that has been postponed. Full stop. Subsequently, the present petitioner made a representation before
Secretary Gaupura Association.
before the Secretary Gambra Association, West Young District AP, challenging the legality, validity, and the jurisdictional authority of the Gambra village. Yes, video.
For
West Young District Gambra Association, in person to his, if considering his representation, the subsequent parwana was also stayed, and there was the decision of 5/2/2025 was kept in abeyance by the authority concerned. But surprisingly, again on 1/3/2025, another parwana was issued against the present petitioner, asking him to appear before the authority concerned on 17/3/2025. On being aggrieved to the said parwana dated 1/3/2025, the present petitioner has approached this court and paid for stay of the said parwana dated 1/3/2025 till disposal of the present petition. Next, but considering the issue notice is going. The records they kept there in village association Gambra,
Yes.
records to call for Kuriba. The records has to be called from earlier from the Keba authority. That was then again from where from the record was to call for?
From Gaupura Association.
From Gambra Association, but you have filed a subsequent your representation also.
Yes.
Acha, Gambra Association of West Young Gambra Association of record call Kuriba. Considering so and so, the operation of the parwana dated 1/3/2025 is stayed till next date of listing. List accordingly after 3 weeks. Okay. Yeah, because of time.
Yeah, this Malad. Malad, this civil revision is filed in connection to money execution number 13/2020 pending before London Civil Judge Senior Division at UPI, Malad. Here, the fact of the case is that, my lord, since 2015, on dated 1/5/2015, one person led Murang Peter. This person has taken loan in my name from the respondent number 2 bank, my lord, by deceitful manner, my lord. He was obtained my documents and my signature, stating that he will open account in my name in that concerned bank, that is in respondent number 2 bank, my lord. So after that, my lord, I have no any knowledge for taking loan in my name by this is like Murang Peter, who is the elder brother of respondent number 5 here in my lord. So what happened, my lord? Thereafter, in the year,
party to that person.
yes, my lord.
That person you have not made party.
My lord, person has already died in 2017. So now I made party to his younger brother, one Murang Tadar. So what happened, my
That's
lord?
respondent 5.
Yes, respondent 5, my lord. So in the 2018, my lord, I have received notice from Civil Judge Senior Division and I was directed to appear before the Lok Adalat, my lord. On Lok Adalat, that is in my lord, notice is in my lord, page number 23, my lord, in my petition, Annexure B, my lord. So this, after receiving this notice, I went to the bank, that is in respondent number 1, respondent number 2 bank. So I inquired that this late Murang Peter has taken loan in my name, sum of which 4,50,000. So thereafter, again, matter was fixed on Lok Adalat, that is 9/3/2019, my lord. So I went to Lok Adalat, and after discussion with the younger brother of the late Murang Peter, who was taken loan in my name, my lord, so Murang Tadap. So we have discussed, we have rounds of meeting in the village level, my lord. So thereafter, this younger brother has agreed to clear all the dues, all the liabilities of the bank, my lord. So accordingly, matter was settled in a Lok Adalat, that is page number, my lord, page number 24, my lord. Page number 24 is, my lord, awarding of Lok Adalat in my petition. Type out is, my lord, page number 25. May I read out the order, my lord? Dispute between the parties having been referred for determination to Lok Adalat and the parties having compromised or settled the case matter, the following award is passed in terms of the settlement. Sri T.T. Tava, branch manager of Arunachal Pradesh State Cooperative Bank, FX Bank, Chimpu branch is present, and Sri Tarak Dasap, Sri Murang Tadap are also present. Tarak Dasap is my lord petitioner. Murang Peter is a respondent number 5 here in my lord. Sri Murang Tadap has agreed to pay sum of rupees 5,50,000 only on behalf of Sri Tarak Tasap to the bank. Next page, my lord, page number 26. Sri T.T. Tava, representing the said bank, also agreed with the proposal of Sri Murang Tadap on behalf of Sri Tarak Tasap. Both the parties have mutually agreed to settle the matter. The said amount of rupees 5,50,000 only will be paid to the bank by Sri Murang Tadap within 10 months from today. So after this settlement, my lord, parties has agreed by the bank authorities also. After this settlement, I was peacefully living in the village, my lord. So what happened, my lord? Thereafter, on that on some days, I have received notice from a civil judge senior division. That is page number 27, my lord. I have received one civil warrant. I was being called by the concerned police station from Balijan. They have informed me that there is a civil warrant in my name, my lord. So I inquired the matter, and then it was found that the respondent number 2 has filed money execution petition before Learned Civil Judge Senior Division at the UPR. And they have made party, implead the judgment debtor to me, my lord. But by taking the reference to the settlement being made on Lok Adalat, that is 9 March 2019, my lord. So as per settlement made in the Lok Adalat, my lord, one Sri Murang Tasap should be the judgment debtor in the case, my lord. So they have made me party, stating that I am the principal debtor of the bank, my lord. It is fact that my name is there, my lord. Entire record is there, but I have never been taken money from the bank, my lord. So they have filed money execution under Order 21, Rule 41, my lord. So if they are not honored the decision of the Lok Adalat, my lord, so there is no decree, my lord. If there is no decree, so money execution may not be filed, my lord. So if they are assuming the judgment, assuming the order of the Lok Adalat, that is 9/3/2019, that may be assumed as a decree, my lord. So
Is there anything that it is a settled principle of law that once matter is decided before the Lok Adalat, you cannot go for an appeal against that order?
My lord,
That is there. But the
yes.
question is that whether their execution is also barred. I don't
Yes.
think so. If you not paid the money, then obviously where the petitioner will go or the decree holder will go. May not be considered as a decree holder, but you are saying that you are debarred from executing any for execution also. Whether there is any.
Yes, my lord, execution can be filed by the bank authorities as per decision being made in Lok Adalat, my lord. But my continuation is that bank authority should make party to judgment debtor as one Sri Murang Tadap, who has agreed to pay some of his 5,50,000 to the bank authorities, my lord. So they have not made him as a judgment debtor in that money execution number 13/2020, my lord. So that is my condition, my lord. So thereafter, civil warrant was issued against me, and I was appeared before the civil judge, and I have taken time for refund of the money. But again, on 6 March 23, they have issued me civil warrant, my lord. That is in my lord, page number 29, my lord. Again, civil warrant is issued against me.
No, on 27, you received a civil warrant, you approached this court,
Yes,
paid for time for the
Yes, my lord.
money.
yes, my lord.
And then again on 6/3.
6/6/3, I was issued a civil warrant. Because I am, my lord, I am a farmer, I am living in the village. and I have no such earning sources, earning money, my lord. So I was taken time even on 6 March, I failed to pay the money which agreed in the Lok Adalat as per their money execution. So again, civil warrant issue, my lord. So here in the case, my lord, as per order dated 9 March 2019 in Lok Adalat awarding. So bank authority, respondent number 2 should make party to respondent number 5 herein, my lord. Judgment as a judgment debtor. In fact, my name may be there, my lord, as a principal debtor, but that person should be implicit in the money execution, my lord. That is my prayer, my lord.
You are representing bank.
Yes, madam. 1 and 2. Madam, Lordship is aware, but the revision power is very limited, madam. It's always supervisory power when the court exists its jurisdiction and or totally the orders, madam, illegal,
If there is any
patently
purposity
illegal.
or
madam.
illegality,
Yes, but your Lordship has already seen. He has all along been agreeing to pay the amount, madam. So when he is not unable to deposit, madam, what's the option for the civil court to do, madam? That's a warrant of arrest only, madam. Civil warrant, civil warrant. Madam. There's no illegality as such, madam.
But before coming to this court,
Yes, ma'am.
whether you have approached the learned trial court below where the money suit was pending or execution was pending,
Execution spending, madam.
that this Nurang Tokat or whatever, he should be one of the judgment debtors. Is there any representation
My lord,
from your
so
side?
far I apprised before the learned court below.
No,
That is
appraisal will not know
yes.
whether there is any application filed by you.
application not filed, my lord. Application has not been filed.
What to do,
But
sir?
they have
The
insisted
question is-
me to pay all the dues, my lord. In fact, my lord, as per order or as per awarding of the Lok Adalat, my lord, even I am not liable to clear all these dues, my lord. If we honor the decision of the Lok Adalat, my lord. Even respondent was present on the day of awarding of.
But the bank is also bound to file against you because you are the principal debtor
Yes.
or in your name, whether
Hmm.
by cheating or cheating in personation or whatever, but the loan was obtained in your name.
Yes.
That means you are the before the bank as if
Yes.
you
Yes,
took the loan.
That's I'm agreed, my lord.
That is the question.
That's
in
I'm
fact.
agreed, my lord. But my lord, as per decisions, as per settlement, my lord, in the Lok Adalat, my lord. So this person, the bank authorities, why they
So
have
you have
paid?
made party the member secretary also.
I think that's not necessary.
But the one thing is there, Mr. Toko.
Madam?
Question is that in the order,
Yes,
in the Lok Adalat,
yes,
if there is suppose any agreement between him and the said younger brother of the deceased, whatever, there may be an agreement, or
Yes.
he may take the responsibility that I will pay. How the look in the Lok Adalat, because his brother has no locus standi before the Lok Adalat.
yes,
He is neither a respondent nor this thing
yes,
in the money suit.
yes,
And so it is obviously filed against him only,
yes.
or whatever that was the disposed of. But in the Lok Adalat, how
No, madam.
it can be compromised or it can be settled with a person who is not even the party to this suit.
Yes.
That-
But-
that is- that is
but-
also
What happens, madam? Your lordship is in Lok Adalat is a totally mutual settlement between the parties.
obviously.
madam. And we have not issued the Lok Adalat didn't issue notice to that person, madam.
obviously.
Notice was issued to him.
To him only. Yeah.
He brought that person saying that he will be paying on my behalf, madam. And everything.
That, but whether you think that that recording of the name of the person that he is agreeing to pay, because Lok Adalat or the court has no connection with that person.
No,
Because
obviously,
he is not
obviously
before
not.
us, so
No,
he has
no.
no locus standi to file any application or
No.
whatever.
No.
But the Lok Adalat orders specifically it is stated that said person is agreed to
Yes.
pay so and so. That should not be, I think.
That
Because
ought
it
not
is-
to have.
Ought not to have. Been.
Yes.
Yes.
Of course, madam, 2019, he ought to have at least said that when he is unable to pay, he could have filed, your lordship is aware of the summary suit also against that
Yes.
person. It's summary suit, your lordship is aware, it can be settled within 15 days or so 1 week. He ought to have filed, madam. Then
Now.
it would not have reached this far, actually. Of
now
course,
what
I
do you
understand the
think? Member
difficulties.
secretary is also a necessary party here.
My lord, matter was settled in the Lok Adalat. It was organized by the District Legal Authority Service. ma'am.
Obviously.
District Legal Service Authority. So that's why I made party in legal, because if settlement was made before the chairman of the legal service authority, so if we have honor on the decision of the Lok Adalat, my lord, so the bank authority should make party to this person also. So if they are not honor, they are not, the bank authorities are not honor the decision of the Lok Adalat, my lord. So there is no decree, my lord. So bank authority cannot file money execution against me, my lord.
No, that I think that legally that would be not be sustainable. It's a judicial
No,
authority.
if they are not
Lok
agreed with
Adalat.
the decision, my lord, decision of the Lok Adalat. They are not agreed with the decision of Lok Adalat.
They agreed with the decision of the Lok Adalat, and
Yes.
rightly we have pointed out there cannot be any decree in the Lok Adalat. But it question the order of the Lok Adalat is not appealable. It cannot be made an appeal, but for execution they definitely can.
My lord, I have
Because
not,
obliging the order of the Lok Adalat or whatever, you have not paid the money. There may be some time period or whatever. So that way the bank authority is bound to file your execution case.
my lord, I am not appeal revision against the Lok Adalat, my lord. Just my contents against the money execution being filed by the bank authorities, my lord. If their execution, money execution file on the basis of the decision made in the Lok Adalat.
You can address, you can file a petition before the executing court that
Yes.
the person, because against the order of the compromise or whatever before the local they have approached with the money execution matter.
Yes.
So you can approach the authority concerned with a representation or with a application that he
Yes.
is also one of the necessary party in the execution case,
Yes.
but without approaching this. court.
My lord,
Otherwise, he has rightly pointed out, is there any illegality, perversity of the order of the executing court? I don't think so. If it is not paid, then definitely warrant or warrant of execution will be definitely issued against you. That is the procedure.
yes, my lord.
Otherwise, you will be put in the civil imprisonment.
Yes,
That
my
is
lord.
that is the
That is it.
procedure. At best, you do one thing. We cannot pass this. What to say, Mr. Tofu? The
Madam.
3 and 4.
I think the
1.5 is that the
My lord,
private-
5 is the person who take responsible to
Yes.
pay the money. So my lord, this person may be issue notice, my lord. So why he should not be made party in the money execution, my lord?
Otherwise, you are representing 1 and 2.
1 and 2.
Yes, 1 and
3 and 4, I mean, humble understanding, they are the quasi judicial authority, they shouldn't be
Yes.
made as a party before, because
That is
otherwise,
the questionable thing. Number
otherwise,
3 and 4.
if people start making the court as a party responsible.
Similar matter was already decision being made by this honorable court, my lord, which was taken in the district of Lohit, my lord. The decision was made before the Lok Adalat, but it was challenged by the parties.
Right.
And this honorable court has referred back to re-hearing of the matter in the Lok Adalat, my lord. That's today I have not bring that.
Re-hearing of
order.
the matter.
Yes.
Before
That's
Lok
another matter.
Whatever, in another matter.
Upon them, whether they should be made as a party, I don't think they should be made as a party.
My lord, my submission that if the decision was made before the presence of Lok Adalat and presence of the chairman.
Do one thing, you have already appeared, will issue notice to respond number 5. Issuing notice to respond number 3 and 4 will be kept abase at this.
Yes, my lord.
Let us hear the matter.
Yes,
Let him appear before the court.
yes, yes.
In the meantime,
Yes,
I'm just saying, you take some decision. If you can file a representation before the executing court, because on the basis of definitely you are rightly you are saying that only
Yes.
pursuant to the order of the local Adalat only, the someone had agreed to pay so and so, that is already reflected in the order of the local Adalat.
Yes.
That cannot be denied by the court also.
Yes.
So on the basis of that, whether he can be made a implied as a party, because otherwise it is limited power vested in this court. So if you go by the otherwise, because you are the person who took
Yes.
the loan in the court,
Yes,
in the
yes.
record. So against you only the execution was filed, and the in non-fulfillment of the warrant and all that, the London trial court will issue the warrant.
Yes.
In the apparently there is no illegality or perversity in
Yes,
the
yes.
order of passed by the so and so. So we'll do one thing, we'll issue notice to the respondent number
Respondent
5
five,
at this 5 at
yes,
this stage. Let us hear the matter. And you want any record here? Record is, I don't think any record.
My lord,
will be
even money shoot was not being filed by the bank authorities. It was just made complaint before the court and matter was placed in the Lok Adalat. So notice was issued to me and accordingly I was appeared along with this person. respondent.
It was
No,
before.
money suit was filed by them.
No money shoot was filed,
No.
my lord.
I'll tell you, it was before the, your lordship is a Baki Jai code, okay, that Bengal Public Demand Recovery Act. Under that, the matter was.
Even in a notice, no money shoot number is there, madam.
No,
which
I'm
was
saying it was under BPDR, madam. Your lordship is our Baki Jai case, we say in
Yes,
Assam.
yes, I know.
That Baki Jai was there.
But Bhakti Jai proceeding after The order of the, this local, you have.
No, no.
Sri Pakistan Court.
No. Before the matter was sent to Lok Adalat, this matter was before the Bakijai court. This,
But why you directly approach the Pakistan instead of filing any money suit?
no, that is.
Because sometimes there is the money suit also, suppose
Uh,
recovery was not there. If
yes.
you cannot recover, then obviously one person will approach to the Pakistan
The
or
Arunachal,
recovery.
Arunachal, there's a special notification, amendment has been made to the Bakijai.
Directly can go,
Yes.
one person can go to
Yes,
Pakistan.
yes,
I mean, Bank of.
yes. That's why any bank, in Arunachal, that notification is there. The Bakijai has
Maybe
been.
a different, but
Yes.
otherwise the person, if on
That,
someone.
that has been amended in Arunachal Pradesh in context of Arunachal.
On the next occasion, he brought all these things also
Yes.
for us. And if he has said that without any being
Yes,
has
yes.
been filed, the matter was before the local law, then it went again, it was
Yes.
going. So there are some points to be
Yes.
decided, in fact. Hard so and so for it, Mr. Topoli, that we are already for 1 and 2, no formal notice is required to be served and so and so. Issue notice to the respondent number 5 and it is issuance of notice against the respondent number 3 and 4 is kept in abeyance at this stage. When it can be listed then? You need any record here?
My lord,
I
yes,
don't
my
know,
lord,
revision,
my lord, I have, my lord, that execution petition may be called for, and then, my lord, till disposal of the matter, execution matter may be stayed, my lord. That's my humble prayer, my lord. Otherwise, civil court will issue me warrant and return me, my lord.
Revision record.
That is, my lord, my humble prayer.
Yeah, everything
Not
is there.
necessary, but your warrant has been issued, na?
Yes, my lord.
Which is the order you have put in challenge?
My lord, I just paid for.
No, order the.
Stay, my
under
lord,
challenge
the
is
6-3, my lord,
6-3.
6-3-25, my lord.
60-25 to stay. Okay, we are staying next. It will be listed after 3 weeks.
Deeply.
Yeah, I know it's precarious condition for him, but
Obviously,
ultimately,
he is also facing a that condition, peculiar condition.
but ultimately, the aim of revisional court, your lordship is aware, he will be in difficulty at the end, he has to do something in between. When
The
matter
person is
spent.
still, you have made any contact with that person?
Yes.
That
Yes,
younger
yes, my
brother
lord,
who
he is-
deceased?
Yes, the person is in my same circle, my lord. Person who is take responsible to clear the dues, my lord.
It will be a
Maybe
temporary.
outside the court also, you can talk to
Yes,
him
Yes,
also.
yes.
Why he had done all these things?
Otherwise, this will temporary relief only, your lordship. Then,
It's simply temporary.
yes, obliged.
Okay.
Number 9.
Mr. Parme, you are having some cold cough and all.
Yes, my lord. No, no. This, my lord, I am challenging, my lord. Charge it, my lord. In connection with my lord, all of PS case number 14/23, my lord.
Hmm.
Under 447 IPC with section 3 PDP. Here, my lord, I try to impress my lord that this case is in manifestly instituted on Malapai, my lord, past my lord. I try to impress on that, my lord. This is manifestly in counter to my FIR, my lord. This has been instituted, my lord. And that, my lord, victim, my lord, is not there, my lord. Third party, my lord. Though, my lord, in criminal case that may be not relevant, by, but while exercising the 482, my lord will look into other circumstances also, my lord. So, FIR, my lord, will find, my lord, at page number.
Person is not, I'm not so good. He will come and do it. He's from Manipur. But sometimes we register to principal seat also. I have seen it.
47, my lord.
47.
47. Sorry, my lord. 47 is my FIR, my lord. I am not going to the next number 12, page number 58, my lord. This is the FIR against me, my lord. Body of FIR, my lord, will find at page number 61, my lord. 61, my lord. 61, my lord. I am reading this, my lord. Page number 61, my lord. Subject, my lord, from subject, my lord, page number 61, my lord, 61, subject. FIR against such and such, my lord. This is my father, my lord. FIR against such and such, my lord. This is my father, my lord. Now,
He is your father.
father, my lord. Now, that had been interfered by this honorable court, my lord. The proceeding against this has been interfered, my lord, against my father, my lord. And city such and such, this is me, my lord. For damage the public property of the government higher secondary school boundary wall and committed the offense of giving false information to the police and doing wrongful restraint during time of official land verification 17 such and such. Sir, most respectfully, we have the honor to inform you that on dated 17 August 2023, we the undersigned who happen to be a responsible citizen of Alo area has visited the government higher secondary school premises to make verification of the area after receiving various complaints of the land encroachment of the school premises. It is pertaining to mention herein that we have visited the all school premises of government higher secondary school Alo and have also visited the area of such and such after receiving a circle from the land revenue and settlement officer for joint verification of the school boundary and the enforcement area. And there was nothing illegal in our part because everything was done illegally. But Sri such and such has mislead the police Alo by giving false information to the police, which lead to register a false criminal case against us at Alo PS. My lord, you kindly notice, my lord. The FIR itself disclosed, my lord. This is counter to my FIR, my lord. It is also pertaining to mention here in that we have never made any trespass and our visit was fully legal because after obtaining a circular from DLRSO for joint verification, we visited the area, but we have been made as a criminal and accused by giving misleading information to the police. Therefore, your good office is highly prior to register a criminal case against such and such for giving false information intentionally and restraining the official team, including us, that the other offense that committed by the such and such where damage the public property, secondary school wall of government higher secondary school allow illegally encroach the school land and damage the septic tank of the such and such. This such and such has lost a FIR against us to save the above mention of offense and have committed by him and his father. In view of that, we ask you to good office to register a criminal case, my lord. Now, 2-3 documents I will invite kind attention of my lord. This is motion is the my lord. Kindly have a look at page number 69, my lord. 69, my lord. 69, my lord. This is part of charge sheet, my lord. Page number 69, my lord. This is part of the charge sheet, my lord. My lord, kindly see with this. This is by the SI, my lord, concerned investigating officer, my lord. He say, my lord, the PO is boundary wall of government higher secondary school Alo. About 1 kilometer west, the LS accused, this is me, my lord. Son of such and such has construction wall along with the retention wall, due to which septic tank belong to occupant of the government quarter has been damaged, but it was found that the same has been repaired by LS person subsequently ordered by the deputy commissioner, my lord. During the construction wall, my lord, some damage happened, my lord. Now that has been reconstructed. Even after this finding, my lord, thus concerned IO, my lord, filed the charge sheet, my lord, under the pressure of the private respondent herein, my lord. Then another document, my lord, I kindly attention, my lord, at page number my connection number 1, page number 35, my lord. 35, my lord. Where is a this say, my lord, this was earlier issued to my father, my lord. Where is a complaint is received against you for encroachment of government land and cause damage to government art cutting, construction of your RCC building. Where is a spot verification conducted on 8/8/2020 and found that the said quarter is on verge of collapse due to art cutting, construction or building. The government is in precious condition. Therefore, you are hereby directed to initiate immediate restoration construction of wall to to protect the government quarter and to confine new construction activity within new allotted area, failing which necessary action shall be initiated area. Now, my lord, see here, direction was issued by the concerned authority, my lord. The land belongs to the government, my lord. The concerned authority of the land said, direction issued to me, my lord, this is bus of police, my lord. You need to reconstruct, my lord. Accordingly, I reconstructed in terms of this order, my lord. Now, during reconstruction, yes, my lord, unintentionally some damages happened in the septic tank, my lord. Now, that also I repair, my lord. Septic repair, my lord. That is a matter of record, my lord. Even then, this charge has been filed, my lord. Now, my lord, you see, my lord, the section invoked, my lord, in this case, my lord, is 447, criminal trespass, my lord. Now, my lord, you know, my lord, it is a case, my lord. Normally, trespass simply is not a criminal offense, my lord. It should be criminal trespass. When criminal aided in trespass, my lord, that require intention, my lord. Ultimately, any for punishing a person under, my lord, criminal trespass, my lord, the requirement, first requirement of my lord, would be criminal intent, my lord. Now, here is a case, my lord, on the record, my lord, it say, my lord, the was, my lord, between my lane, allotted lane in the school boundary, you are in bars of Polas, my lord. Now, accordingly, I repair, my lord. Now, past time, my lord, under the authority of school principal, my lord. Second time, my lord, is duty again, some misactivity by the occupant of quarter, my lord. That again, in the past of police, my lord. Accordingly, in terms of that, my lord, direction issue by this concerned authority, my lord, who is the example, who will be the victim in this case, my lord, who is the owner of the land, my lord. I reconstructed, my lord.
So who were the informants? In fact,
This
there
is,
are
my lord, totally, my lord, private. They are, my lord.
There are 3, 4, 5, 4 numbers of informants are there.
Now,
Who are they?
they are, my lord, local in, they are the land, they are the landowner of that area, my lord. Earlier, my lord, this Alo town, my lord, belong to them, my lord. Now they saying we are the landowner, my lord. So they are use some, have some extra governmental, my lord, authority in those area, my lord. So under that pressure, this, my lord, though I specifically, I find it, my
Where
lord.
is your FIR?
My FIR, my lord, will find it page number. Page number 50, my lord. 50, my lord. May I read this, my lord? With due respect, I could like to bring your kind notice on the incident that the 17th of 23 occurring at the private residence of the undersigned. That I have got information of official visit of Department of Land Department my resident on 17 August 2023. Accordingly, I was waiting for the official at the entrance of my residence. Suddenly, at around 10:09 a.m., once he such and such entered along inside my entrance gate, and when I request him to leave the premises by saying that only official will be allowed, he left the place, and thereafter leaving my house, he threatened to kill me by saying, "Jinda rahega to ek bar milega." After he left the place, the office of the land management department came in around 10:45 p.m. Few minutes after the arrival of the official of the land management department at around 10:49 a.m., group of people forcefully entered into my premises of the house, even after my repeated request and warning to leave my premises. One unidentified person first entered my premises with a doubt on the above fact that pre-plan to commit above offense. It is not possible to commit a house trespass by such a huge number of persons without a proper planning, and especially since one of them carried doubt which is dangerous weapon. If no action is taken against me, I fear that they will come again in such large number with such dangerous weapon that will cause risks to life of me and my family, and also risk of damage to property. They all enter my premises with a common intention, with the preparation cause of doubt, and putting my family member in fear of hurt and assault. The entire incident was witnessed by my elder brother, such and such. This is now, if my lord will see in verification, it also, my lord, during the construction of wall, my lord, they are saying, my lord, the official verification say, my lord, while construction, I have enclosed 50 centimeter, my lord, 50 centimeter one side and 80 centimeter other side, my lord. Now, normally, when retaining one that I humbly believe unintentionally can happen, my lord, 50 centimeter, 80 centimeter, my lord. Now, in absence of those, my lord, ultimately this criminal case, my lord, if my lord, the mischief under the PDPP might also require minimum intention, my lord. Is the section applicable also depend on the IPC, my lord.
Okay.
So my
Yes,
humble
Mr.
summation is this, my lord.
Yes, Mr. Now, what is the stage of the charge sheet has already been filed?
Yes, ma'am. No, someone is, my lord. I have.
Charge sheet,
Fine.
Charge sheet filed.
it is already charged. As many as 7 private respondents are there.
7 private. They are the basically
One respondent, one is state, and from 2 to 8. They are private.
they are all the informants of the case.
Informant, my lord.
Informant.
They are the union, my lord. They are having some, I would say, my extra government power at their, my lord. Otherwise, my lord, if I let to go recall, my lord. I have produced all the relevant record also, my lord. That was also not a made of charge sheet, my lord. I can understand, my lord, that yes, some pressure. I was also under pressure, my lord. Even if he find with my lord, I have correct all the thing in terms of direction. Who is the victim in this case, man? That is a government, my lord. Government is directing to reconstruct. I have reconstruct, my lord. During the reconstruction, some 80 centimeter, 50 centimeter, 80 centimeter. Then I also surrender, my lord. In septic thing also I repair, my lord. I even after such binding, my lord has by the such, my lord. There's a pressure, my lord. So my humble submission at this is, my lord, let this party may both issue notice, my lord. In the meantime, let my lord some interim, my lord. Otherwise, my lord, let them appear, my lord.
May I take your receipt to the brief of the fact? In this is the outcome of counter FIR on 30th August 2023. On 18th, father and son, that is now petitioner and his father lodged an FIR against these private respondents, as alleging that they are trespassing into their private premises. That trespass was, they were present as per record, but along with the official teams. May I take yourself to the page 45. This is an order issued by the district land revenue and settlement officer for spot verification of the status of the boundary wall. And that was fixed on 17/8. And FIR says on 17th, they allegedly trespassed into their premise. It is an office notice, and these officers issue notice to this private respondent as they are belonging to the community, so welfare society executive members, to present along with them during the inspections. And it was found during the inspection that there was 30 and 50 centimeter encroachment at the end of the boundary school. It was established. And here in this case, allotment was issued in the name of this instant petitioner mother. And now instant petitioner is a grandson of the LOT. And one criminal petition for quashing was moved, and it was disposed by this honorable court, criminal petition number 12 of 2024, for quashing charges against the petitioner father. And it was quashed against the father. But here in the judgment, that is in page 83, passed by this honorable court, relevant portion, may I take to relevant portion yours? Page 83 is a judgment, 87, page 87. Internal page 5 of 8.
Yes.
Para 8. Para 8 letter portion. Para 8, I will may I read this thoroughly. The Learned Counsel for the petitioner has also submitted that the memorandum of observation of the place of occurrence of offense by the investigating officer, which is available in the CD, also shows that the damage caused to the septic tank of government quarter numbers G18 due to construction of wall by Sri Ridham Kato, petitioner herein, was repaired by him as per the order of the Deputy Commissioner, West Siang District Alo. He also submits that the said memorandum of objection does not incriminate the present petitioner. Present petitioner, but in that case, it was
Father.
a father petitioner. He further submits that the statement of the independent witnesses recorded under section 161 of the CRPC implicates only the son of the petitioner. He also submits that only the petitioner, only the member of PAYW, that is a welfare association, whose private respondents, represented by private respondents, whose evidence is of hearsay nature, have tried to implicate the petitioner due to vengeance against the petitioner. On that ground, the father was exonerated from the charges. But here himself, counsel was submitted that independent witnesses have already implicated the son, that is instant petitioner. So, and further, Your Worship, page 88, internal page 6 of 8, para 11,
Yes.
from the middle portion, Mary. Here, earlier our learned colleague has submitted that the corrigendum verification report dated 4/9/2023 issued by the district DLR West Siang shows that there are sufficient material to prosecute the present petitioner as incriminating material are only against the son of the petitioner, not against the father, incriminated available, but incriminating material, sufficient incriminating materials are present against the son, that is now instant petitioner. Then Your Worship, next page, internal page 7 of 889. This is observation made by this court. Para 14, last portion. From the statement of the witnesses available in the case diary, it appears that all the independent witnesses, except the members of PAYWA, have implicated the son of present petitioner only. As the son of the present petitioner had filed an FIR against the member of PAYWA on 18/8/2023, the attempt to implicate the present petitioner by the member of PAYWA in their statement made under section 1 due to vengeance may not be ruled out. It was regarding his instant petitioner father, not against instant petitioner. And here also it's made, there is a sufficient independent witnesses as per the case diary that which implicating the instant petitioner. So there is a PDP Act implicated on the PDP Act under section 3. And there is a findings of the there are also verification officers that there was a demolition of septic tank of the government quarters nearby the school boundary wall, encroachment of the school boundary wall. There is sufficient materials, even in this petition, documents available in this petition itself is establishing prima facie against him. So at this stage itself, Your Honor can exercise the power of inherent jurisdiction by dismissing it without, it may take another wastage of time to issue notice to the private respondents who are just merely an informant. From record itself is repeals. And IO charge sheet, as per the charge sheet, . . May I take your worship, page 64 is a charge sheet. Charge sheet pertaining to the counter FIR lodged by the private respondent against this instant petitioner. And
I
for
had the page number.
page number 64 is a charge sheet. 64 to relevant portion is 67, page 67. Page 67. One take disclosure during investigations. 1, 2, 3. Third para. Second last para. IO, after conducting thorough investigation and visiting the PO, his finding reveals that after examination of available witnesses and documentary evidence, it is revealed that Sri Ridham Kato, instant petitioner, and Sri Duken Kato, a father who was already exonerated, illegally encroached and destroyed the government property. The verification report of DRRSO West Siang District Alok cleared that the area under possession of the alleged accused, Sri Duken Kato, represented by alleged accused Sri Ridham Kato, has encroached 50 centimeter and at one end and 80 centimeter on the other end of the government higher secondary school boundary wall constructed by Paktuau Welfare Youth Association. That is constructed by this executive member welfare association members. And septic tank of government quarter has been dismantled. It is already clearly established from the material available on the record itself by the documents enclosed by the petitioner
Yes, I'm not.
himself.
But I paid to understand submission method, learned PP method. I presume method.
He that the matter should be disposed of at the admission motion stage.
Yes, it may be trial may be taken place before the learned trial court, and this quashing petition may be dismissed. My prayer, humble prayers.
I pay, referring to those method, statement method. I am presume method. Learned PP is trying to testing the order passed in the earlier criminal petition method. How that came money? He is if he is referring case number 64, saying that there is prima facie case. In this 67, there is a prima case against my father also. If I allow to, after against available witness and document evidence, it is revealed that this is such and such Duken Kato, Ellisly, and Cross and District. That is my father.
Seconds, both
Having said that,
it was fine.
Yes, that's why this honorable test already tested against those against my father. Now he is referring to my submission in those cases. If my lord has seen those, I am tested those statements against my father, my lord. Today I before my lord say whether from the source my lord in any offense against the present petitioner made out that I am testing my lord, not the other earlier case, my lord. How he is trying to mix up the whole issue, my lord. Earlier case is again of my father, my lord. Today I am the son, my lord, is independently testing, my lord, the case against Sarsit against me before my lord, my lord. Now, issue here is my lord has seen, my lord. Yes, Sarsit, they have submitted, my lord. There is a Sarsit against me, my lord. That's why I am before you, lordship, my lord. The Sarsit under which section, my lord? That is the under PDPP, my lord, under the 447, my lord. Now, if my lord, that is so, my lord, the minimum requirement, my lord, under 447, my lord, if my lord,
you want to say that we have to produce the case record and case diary also
No.
in regards your case.
yes, my lord. Other, that's
Yes,
why my
obviously, Mr. Kalu is submitting basically on the judgment or order passed by this court in connection to your quashing petition for your father.
my lord.
As there, it was observed that there may not be any materials against your father, but your son is implicated.
If,
Son means you were implicated.
my lord.
That was the observation of the earlier court while passing the order. So he is saying that on the basis of that only it can be presumed that your father may be not be involved, but you were definitely involved, and as part of the charge, it also says that you not only enforce upon the school boundary and you dismantle the one septic tank of the, but yes, obviously from the,
That is true, my lord.
from here, the inspection report and all, it is seen that those were already
Repair. That I should submit that observation, gentlemen. Therefore, my lord, I am testing this case on against the son to my lord. Now, therefore, my lord, yes, there is a charge, my lord. There is some allegation, my lord. Whether by under the 482, my lord, ultimate test, pass, my lord, whether that was manifestly instituted against me or my lord. Now, FIR itself say, my lord, this is counter to my FIR, my lord. That satisfy the first provision, my lord. This is manifestly invoked against with nullify the, my lord. Second, my lord,
Yes, yes, that is.
even if there is a allegation, my lord, whether from that, my lord, any conviction is possible, my lord. Now, this
To be
PO
looked at.
report is a part of charge sheet, my lord. PO report say, my lord, there is no. Now, my lord, will kindly, the encroachment, my lord, is 50 centimeter, 80 centimeter. My lord. That can happen, my lord, during, even if by two neighbor, my lord, without any intention, my lord. If there is no intention, my lord, there cannot be
Heard
conflict.
Mr. Alpami, the learned counsel for the petition. And also heard Mr. G. Talu, the learned additional PP, appearing on behalf of state respondent. This is an application under section so and so in connection with so and so. Full stop. It is submitted by Mr. Pami that from the plain reading of the FIR itself, it is seen that it is a counter FIR against the, against the order, against the FIR filed by the present petitioner against the association of the informants. Further, he submitted that the case is registered under section 447 and 447.
3 and 3 PDPP.
447 and 3 of the PDPP Act, which is not at all applicable against the present petition. He submitted that from the charge sheet as well as from the inspection report submitted by the authority concerned. It is very much clear that after the direction of the authority concerned, he had already repaired the septic tank and the wall, which was, as it was alleged to be damaged during the construction of your retaining wall or what?
Retaining wall between me and the quarter,
Retaining wall between
the school and the my
campus and quarter and his boundary. He further submitted that to attract section 447 of the 3 PDPP Act, the intention is the first ingredients to be filled with, but here there cannot be it cannot be held that there was an intention for encroachment of the government property of the school boundary and the government quarter. More so, as per the allegation also, only the encroachment was only 30 centimeter and 50 centimeter in the boundaries, which may take place at the time of the construction of the boundary wall, but there was no such intention for any encroachment. Accordingly, he submitted that till the disposal of the present so and so, the further proceeding against the present petitioner may be stayed, public suspended, till it is suspended. Further, he submitted the father of the present petitioner has already been exonerated from this case, and the petition for quashing filed by his father is already allowed by this court. Next para, Mr. Talu, the learned edition PP, submitted in this regard that from the order judgment and order passed by this court in connection with criminal petition number
Criminal petition number 12 of 2024. Page 83.
no, 87 you're saying?
87 is a relevant portion.
Whatever, 85, I think it starts from 85. First in criminal petition number 12 of 2024. Wherein this court has observed in para 14 and sorry, para 8 and para 11 vis-a-vis para 14, that the from the statement made by the witnesses on and the other and on the basis of the documents relied by the petitioner, it is seen that the present accused petitioner is incriminated by the with other witnesses, and there was no such criminal, there was no such incrimination against the father of the petitioner, and on the basis of which the earlier petition was disposed of by quashing the criminal case against the father of the present petitioner. But from the order passed by the learned, but from the order passed by this court, it is very much evident that there are sufficient incriminating materials against the present petition, and it is him who also encroached the land as stated in the FIR as well as in the charge sheet itself. Accordingly, he raised objection and submitted that the present petition may be disposed of and dismissed at the stage of motion, at the motion stage itself. Next part, considering the entire facts and circumstances of this case and hearing both sides, as well as considering the annexures file along with the petition, etc., I find that the scanned copy of the LCR along with the case diary be called for, and further proceeding against the present petitioner pending so and so be stayed till next date of listing. Okay. Your present petitioners will be listing, we'll see to it, and other respondents will issue notice, take steps for the other respondents. We'll see the matter if there is any material against you or not.
Highly.
Otherwise, it is seen that there was a 50 or 30 centimeter encroachment that has already been repaired, septic tank. Maybe there may be an intention for the encroachment, as we have said. There are materials also. May not be against him, but may not be against his father, but may against him. That may be exist. So I don't want to quash the petition at this stage, or don't want to pass any order at this stage. So the other side is appealing. Ms. Jenny is appealing in item number 27. It was fixed at 2, in fact. That day also I asked him, Mr. Tagum Tabak, he is absent. Why? Without his absence, it cannot be heard. For the private respondent, where is the advocate? He is there otherwise for the, from the state, you are here? Because his presence is required, no? That's
Yes,
right.
I'll just.
Otherwise, he is available?
He should be available because on the last occasion when the date was being taken, your lordship, junior was available. Point of time.
Just confirm, because
Yes.
before proceeding with the case, just,
Yes, sir. I'll have a look.
just for timing up. Already come, okay, okay. Yes.
This particular criminal petition about. I need, under 482, read with 439, 2 of CRPC Milord. But I would like to take a lordship to page 15 annexure A1, the impugned bail order granted by the Court of Session Judge.
Page-
Our Subansuri.
Page number?
Page number 15, annexure A1.
Yes.
Your lordship's permission, my lord. The bail was granted on 22/6/2024. I'll just read on, my lord. This application has been filed under section 439 CRPC for granting bail to the accused Nani Chatung, who was arrested on 31/3/2023 in connection with zero pay case number under 302 and 341 IPC of a heinous criminal. Mr. Likhatawin, counsel for the submits that the accused has spent 1 year and 2 months, my lord. 1 year and 2 months in judicial lockup since his arrest. It is submitted that the antecedent accused is clean except being implicated in the present case. Mr. Tawin contends that since the beginning of the investigation, accused has fully cooperated with the investigation and he is doing the trial. Mr. Likhatawin, counsel for it has relied on judgment of C. Tataram, so and so, so and so. Mr. Arbota Lanape Piso and accused that accused being retired police constable has shown his influence in past cases. There is chances of him threatening the witness, those who are yet to be examined. On that day, on 26/2024, Learned P.P. R.R. Buddha submits that one eyewitness of the offense is yet to be examined, and he being in unnaturally, the accused may intimate coerce him so as to depose or give evidence favorable so and so, so and so. Now, I have thoroughly perused the reports. Till 14/6/2024, prosecution has examined 3 witnesses. 2 are stated to be family relative of the accused. This is very important. 2 relative stated to be family relative of the accused, his own sisters. I have also seen CFSL report which indicate that the blood stain found in the weapon of offense was of human being, blood group of any person not disclosed in the report. Investigating officer listed 27 prosecution witnesses and only 3 have been examined so far. Now, the presiding officer was on medical leave for last 6 months. 1 year and 2 months, presiding officer was on leave for 6 months. Apart from the above, it is found that the family members of deceased are continuously protesting with slogans Nami Chatunko Fasido and Be Maddo since beginning of the hearing of the case. What has gone to the mind of the learned judge, even this has gone to that the family members of the deceased are continuously protesting. The protesters' family members of victim may have statutory right to demonstrate, etc. However, they have been strictly directed by the district to stage dharna or demonstrate beyond 100 so and so. They have been sloganeering, showing placards and shouting at the presiding officer just standing at the guard so and so. This is the bad practice trying to influence the court and outcome of the case, including the instant matter. I have seen the executive number so and so, the OC so and so. Later on, Mr. T. Dado, counsel appearing for the victim family, prayed for expunging the sentence lodging FIR from the records. Prayers allow, however, demonstrate our person to obey the orders of the district manager. Now, this is now the operative. The evidence collected by the investigator and the ocular evidence as well as document evidence so that The victim died as homicidal death. I have also given a due consideration to the grounds pleaded by the accused as well as his age. He is stated to be 72 years of age, having permanent residence. How long? Having regards to the entirety of evidence placed on record, this court is of considered view that the accused can be admitted on bail on the following terms and conditions. A heinous crime, my lord. 302. When the charge was framed, that, my lord, the records till 22/6/2024 have been requisitioned by this honorable court. When the charge was framed under 302/201, it was admitted position of the accused that he has burned down all the clothes which he worn on that particular day. He admitted even on the date of when the charge was framed against him. Now, the consideration of learned session judge is only in this particular paragraph that he is of 72 years of age. This is what a bail has been granted in a heinous crime. Had it been up to 10 years or 7 years, things could have been otherwise, but it's a 302. And this, the background of the case is such, my lord, when the accused was produced before the learned Chief Judicial Magistrate, he wanted to confess. And rightly, the learned CGM have given him the time explaining the legality of this particular, in the event he confessed to that particular offense, my lord. So basically, now I would like to take, my lord, which is on record, the deposition of the two systems. Now, going by the deposition of two systems, my lord, whether a bail under 302 could have been granted or not, because my lord also has passed an order on 9/1/2024, that was in a POCSO matter. The lordship was pleased to decide on the perversity illegality while granting bail in a heinous crime. Now, my lord, before I take, my lord, just a background, on 17/4/2023, that's a part of the record requisitioned by this honorable court. On 17/4/2023, my lord, may not be relevant, but we have to consider this aspect also. Accused Nami Chatung is being produced from judicial custody for recording his confessional statement under Section 164 CRPC. The accused is willing to confess his guilt. However, I have explained the accused regarding the legal provision and its consequences. Thereafter, do you have a granted time for reflection, one time for reflection as per law? There's nothing wrong on the part of the Chief Judicial Magistrate, because he's bound to explain the legal provisions and give time for reflection. There's nothing wrong on this part. Now, even after that, hence the accused is remanded back to judicial custody to be produced before this court on 18/4 at 3 AM. Now, even after that, when the charge was framed, my lord, on 22/8/2023, my lord, 17/4/2023, he was produced for 164 statement. He willingly, voluntarily wanted to confess, but the learned Chief Judicial Magistrate rightly has explained the legal provision and gave one time for reflection. Now, at the time of framing of charge on 22/8/2000,
Thereafter, he refused to.
thereafter, at least he didn't confess. On 18/4, he said he will not. He will not on 18/4. But however, on 22/8/2023, even after explaining the legal provisions and giving time for reflection, on 22/8/2023, when the charge was framed, my lord, the charge under Section 302/201 IPC has been framed against the aforesaid accused. The said charge has been read over and explained to the said accused. in Hindi language in presence of his learned counsel. He has pleaded not guilty so far the offense punished under 302 is concerned and claimed to stand trial. However, the accused had accepted that he had burned down all the clothes worn on 22/3/2023 when that particular incident took place. Because the very identity of the accused was from the clothing, because it was a winter time, that he was wearing a woolen cap and a puff jacket. So the guy, it will come in the video footage also, the guy who was wearing the puff jacket and the round cap was the person who has committed this. Now he'll be confessing. That may be extrajudicial confession to his sister. Now, at least this part appears he has burned down and he has admitted to this fact. The identification of so far this accuser's concern is the wearing apparels, the clothes and the cap, and he has burned down all the clothes worn on 22/3/2023, and he has admitted on the day when the charge was framed. It is not a case, my lord, that he was not explained about the legal provisions, but he was explained about the legal provisions. Even after explaining the legal provisions, he admitted that I burned down all the clothes. Therefore, he was given, the charges were framed under 201, my lord. Now, his son, two sisters gave 164 statement before the judicial magistrate. My lord, it's also part of the record. I respectfully tell my lord, to the 164 statement, which was recorded on 31/3/2023.
So it's a LCR.
My lord, my lord. Last time we had occasion to go through that. Nami Radhe,
Also will find that in page number 13.
1-3. No, from 1-3 from which?
CD, the record.
records.
Because in, they have not annexed it in the petition there.
All this 164 statement was taken on 31/3/2023.
Page number 14, you see.
13 years.
13, my lord. 164 statement.
Yes.
13. It starts from Nami Radhe, Rakesh, my lord. My name is Nami Radhe, but my pet name at home is Rakesh. I'm the eldest son of the accused Nani Chatung. I'm working in medical department as a driver and I'm not married till that. I studied up to class 8. Presently, I'm posted at Deet, Lower Subansiri district, Arunachal, and I live therein. On 14/3, I came to Jiro and stayed in the house of my ate, namely Takeyaku, at SSB Gardner Baptist Church, Jiro. I used to visit my village home as and when I got some work over there. On 22/3/2023, I was present in the house of my auntie named Takeyaku at SSB Gad, along with other family members like Takeyaku. On that day, my another auntie, Nami Taba Rinyo, also came from Naharlagan to give school admission of her son at Padi so-and-so. In the night, I go to, on 23 at about 7 to 8, I got up from bed, wherein my auntie told me that in the previous night, she and Ate took my father, namely Nami Chatung, the accused, at Gyati Taka General Hospital at Jiro from Hong Village on the complaint of stomach pain. But after returning from hospital at Hong Village, my father disclosed before them that he had stabbed Mr. Taso Grayu in a corner of Hari village with a knife at the face and chest. To his auntie, So far, it goes, it may be hearsay, so far the son is concerned. But what about two sisters, my lord? After hearing the same, I did not inquire in detail as I don't wanted hear the said incident. Even I didn't know when my father came to Hongjiro and Bandardua. My lord, he is from Bandardua. He is from Bandardua. He is present in Hong village and Hari village is confirmed by this statement itself. Later on, after the incident and before the death of the victim, my father, namely Namicha, telephoned told me that he has assaulted Mr. Tosograyu. This part is not again hearsay. At least once it's over statement. By stabbing with a knife, my father told me that he had attacked Mr. due to some differences among them regarding fund of priest association. According to our discussion, my auntie also told me that my father had attacked Tasugrayu in connection with their difference regarding priest association. I do not know there is my family or personal enmity between father and the victim, namely so and so. Signature of the witnesses so and so. Now, there's a part. Now, two aunties, the next page, Takeyaku, on the day when the bail was granted, they have deposed before the learned session judge. Now, this 161 has to be read comparatively, comparing to the deposition made by them before the learned special judge on oath. Both are on oath, but one is deposition, one is statement under 164. Now, so far, Takeyaku is concerned, 164 statement. I am daughter of late Nami Tala of Hong village and accused Nami Charan is also the son of so-and-so. On 22/3/2023, my sister Nami Tabarino came from Nahalagan to get school admission of her son at Padi Liang School 0. And according to me at my home at SSB Gate, my nephew, namely Nami Radhe, was only staying with me at SSB Gate home as he returned from deed on leave. On the night at around 9 p.m., I go to sleep, but my sister, namely Nami Tabirino, was still there while taking care of her children. Later, my sister Nami Tabarino told me that she received telephonic call from Nami Chatung, accused, informing that he is suffering from acute stomach pain during the night, and assessed myself and Nami Tabarino went to the house of Nami Chatung, and later on, we took him to Gyati Taka General Hospital at around 10 to 10:30 by the car of accused Nami Chatung. The car was driving by our sister Namita Bidinyo. After administration of injection and some medicine at hospital, we returned back to the house of directly at Hong village. After dropping him when we wanted to go back at our home, Nami requested us to stay back for a while and disclosed that on the same night, so-and-so, few hours back, he assaulted Sri Tasugrayu of Hari village by stabbing with knife on his face and chest. He also stated Tasugrayu escaped from the place of occurrence, but he did not know whether Tasugrayu died or not. He did not tell us about reason for attack, but once he told us that he has enmity with Tasugrayu as he snatched the post of President Association of Apatani. On being narrated, I told him that he will be responsible for any eventual in future, and then after I along with returned to my home at SS and so on. This is what? 164. Now, next is Tabarino. And she has given the same statement. Now, my lord, deposition of PW1, that my lord will find PP. Deposition of PW1.
It's in folder C, your lordship will see. It's marked as folder C. There is no pagination as such.
My lord, deposition of Takeyaku, sister Takeyaku. My lord, I read
You
out.
need to read all the evidences.
No. My lord, I'm reading only two evidence. Only two important evidence. On the day when the bail was
For
granted.
cancellation of bail, there has to be something.
No.
Why you need the.
No,
for cancellation of bail?
no. My humble submission is, on the very day when the bail was considered, the deposition were before the learned session judge. When he said he has perused, he had the occasion to peruse even this deposition of PW 1, 2, and 3. PW 1 and 2, they have given 164 statement. In the statement, they said, their own brother said that he has staved Tasograyu. Now, that was under 164. Now, it has come on deposition. Now, the factors to be considered in granting bail of such heinous crime under 302, my lord. When it is confirmed by the sister itself, who took him at the hospital where he had disclosed that he has stabbed Tasograyu, was not taken into consideration while granting the bail. The only consideration was he was there for 1 year and 2 months, and he's 70 years old. That was the consideration. But if we go by PW1 and PW2 statement, Your Honor, even by this deposition itself, it is even sufficient that the accused is involved and he has got no way to escape from these particular charges. Even when it is confirmed in this manner, without having a due consideration of all these factors and on record, so the perusal of the record said by session judge has no meaning, because the record itself reveals that he is involved. And the parameters that to be considered in heinous crime have not been considered. And my lord has had in detail in that particular case of 9/1/2024, my lord has dealt up to Niru Yadav. After Niru Yadav, the Supreme Court has heavily come down again in Deepak Yadav, and in another, followed by another 2024 case. Well, therefore, it's necessary at least to go through deposition number 1 and 2. I'll not take your lordship to, because it is not at this stage your lordship is appreciating or reappreciating the evidence. Because the question of reappreciation and appreciation of evidence doesn't arise because learned session judge has not taken into any of the evidences on record on that day. So even your lordship reads all these evidence, it will not be called as reappreciation. It will be only on of the perusal of the records. I deny the video as my so and so. I did not tell Nami Rakesh that his father had stabbed Ashok Rai in the previous so and so. I did not disclose the IO that Rakesh and Rino collected motorbike of the accused from Hari village. Now, in paragraph 7, he said, I am deposing those facts which I have disclosed before the IO and the magistrate. Now, cross by defense, next page, on the cross by defense, number 3, he says, I have given the same statement before the IO and the magistrate as I am deposing to it. On the cross by defense, I am deposing the same statement before the IO and magistrate. Therefore, whatever he has stated before the magistrate and before the IO is true, it stands. Now, I respectfully thank my lord to PW3, another sister, named Tabarinho, PW3. Lordship responded, Tabarinho. PW3 is some lazy, PW3 Tabarinho. It was given on 14th day, June 2024. Tabarinho, my lord.
Day of June.
14th day of June 2024, Tabarinho, PW number 3, deposition of PW3. It's very important. Tabarinho, so and so. I know the person standing on the door. He's Nami Chatung, his elder brother. I have on 3/4/2023, I've given my statement before the CGM 0. Exhibit P3 is my statement, and Exhibit P3 AB are my signatures. So the contents of the 164 statement, it's proof when he says that P3, Exhibit P3 is her statement and ABC are her signatures. Now, I've stated in P are true and similar to those stated before the investigation. And P3 are true and similar to those stated. On 22/3, I arrived at 0 to pick up my son, so and so. Now, 5. I had brought my son from school, Hakeyuku. So at about 8 p.m., the accused called me over phone and said he had stomach ache and requested me to take him to the hospital. I and Srimati Takeyaku took the accused from his home village. So the presence, even though he's from Bandardoba, he has got another house at home. It's proof. The EMO and the training nurses administered some oral treatment and thereafter we drove him back. Oral treatment. I have given statement to the investor in the presence, yes, at 0. I don't recollect the day and month, but so and so. I don't know the occasion why he has been declared hostile by the London PP. But now, that the only has come on the cross by defense counsel, though I have admitted my depositional statement recorded under 164 CRPC in evidence. Though I have admitted my depositional statement recorded, however, the prosecution side has not read over the entire content of documents to me. It was magistrate read over. Now, it is only has come in the cross that I have admitted my depositional statement recorded under 164. However, this is only says prosecution. It's not a prosecution is not bound to read out. It's a magistrate has to read out. But he has admitted this is my depositional statement. Now, with this 164 statement being after being testified,
Both PW2 and PW3, suppose the
PW3.
sisters, they have not stated deposing accused while adducing evidence. Obviously, you're stating that in 164, they alleged that the the accused petitioner has disclosed that he stabbed so and so.
Yes.
But while adducing evidence, they did not.
No, no,
suppose
wait, he has
it.
testified 164 statement.
No, whatever, in the evidence stage, they did not testify.
No, no, the only thing that whatever he stated before 164 is true. That improves, no.
Yes, it will come later on because it is the case of corroboration and supplementary.
Exactly, exactly.
No, no, I'll come to
But the
that.
question
No.
is that at the time of adducing evidence before the court, they did not disclose the fact.
No,
For that reason, the prosecution has also declared both the witnesses as hostile witnesses.
yes,
That
true,
is the reason
true.
why they were.
True, true. But what my humble submission before this honorable court is the witnesses, when CS proved without any protest that this is the depositional statement which I have given under one CRPC, what more do we do? Because she said, this is the depositional statement I have given before the magistrate on oath. Their CS she stated that the accused is involved in this particular case, and she said, this is the statement I have given and it's true. Meaning hereby, when she has proved, if she denies, the question of, if the rebuttal comes, then the question of corroboration will come. Yet there's no question of denial. But the question of denial doesn't come, the question of corroboration doesn't come because it's not on rebuttal. Of course, had she denied that she was forced to give the statement, she has not given voluntarily, she was coerced to give the statement, yes, the circumstance would have been different totally. The voluntary part that she has given on oath under 164, the statement has been proved through that exhibit. So that corroboration is not required because it is proof that this is my signature, this is a statement given by me. Yes, she has stated that his brother said that Tasograi was stayed by his Nani Chatu. That is 164, one part. 161 part. That 164 has been proved. The corroboration will start when there is a denial or there is a rebuttal. There's no such occasion. Now, the ground, when this particular bail was considered on 26/2024, what were before the learned trial judge? So for the records are concerned, deposition of two very important witnesses, and they have given their 164 statement. Normally 164 statement, my lord, I'll not go back to that history in the background why 164 statement is given. Because the witnesses doesn't make a U-turn. Just to avoid that 164 statement is taken. Even during 164 statement, that also reflection time, everything is given. So 160, the background of giving 164 statement that the witness doesn't take a U-turn. So even after giving 164 statement, normally the witnesses make a U-turn. But here in this case, they have not made any U-turn. They prove the exhibit.
Okay, this part is okay. Then
Now, that is why the corroboration may not be required. Now, number two, what were before the learned trial judge? That admission of part that he has burned down all the clothes when the charge was spread. And Riley, under 201, he has admitted that part. Another two parts, the deposition of two sisters. So, when these particular records were very much before the learned session judge, he has granted a bail. He has granted a bail, citing only one reason that 1 year and 2 months have been passed. Number one, he is 70 years old, and the silent protest of the family members. What was considered by the learned session judge? 70 years old, 1 year and 2 months, and the protest, silent protest, dharna of the family members not to release Nani Chatung. These were the three factors to where the learned session judge has considered. Whether these three ingredients could be considered at a time of granting bail in such heinous crime. But I'm not on the supervening circumstance whether he has misused or abused the liberty granted to him. Or here, I'm not here to say that a liberty has to be curtailed. I'm on the perversity, iniquity, and infirmities of the order passed by the learned session judge. Well, I respectfully tell my lord, all these decisions I have furnished on the last occasion.
Earlier you have supplied this.
I have supplied all the
Let
judges.
me check it. It may be available.
I inquired yesterday also.
Yeah,
I was told that like everything is there.
My appearance had been happening.
My lord, 2014 16 SCC 508 Niru Yadav.
2014, 16.
Two 2014 16 SCC 508. That's it. That's it.
They're all
My lord,
the respondent side and the.
no, I've given. I also have.
Okay.
No, I'm giving another extra question. I don't know
These
whether I
are
have just
also
marked.
respondent side.
If I had
And-
marked, I maybe I have given from the petition side also. I have furnished all.
Okay.
My lord, what Niru Yadav, my lord, in Ligi Ori case, Lordship has gone through Niru Yadav. What was actually Niru Yadav case is,
Yes.
this is about the liberty. Now, my learned friend on the last occasion is saying, once the liberty is granted, it shall not be curtailed. Yes, that's very true. Once the liberty is granted, it shall not be curtailed. But what is that liberty? That was discussed in Niru Yadav. That liberty of an individual is not absolute, but society by its collective wisdom through process law can no liberty.
Which para you are relying in?
My lord,
From the.
there are 9 to 12.
Okay.
9. In this context, a fruitful reference to be made to the pronouncement in Ram Gobind so where this court has observed that a grant of bail through discretionary nature, though discretionary nature, yet such exercise cannot be arbitrary, capriciously, and injudiciously for the heinous nature of the crime, injudicious, for the heinous nature of the crime warrants more caution and there is greater chance of rejection of bail. Though, however, dependent on the factual matter of the matter, in the said decision, reference was made to Prahlad Singh so-and-so. While granting bail to the court has to keep in mind not only the nature and the accusation, but the severity of the punishment. Now, if you go by the severity of the punishment under 302,
Yes.
obviously, my lord, when both the sisters have deposed under 164 as well as on deposition, where they have proved the contents of the 164. If the accusation entails a conviction and the natural evidence is in support of and if the accusation entails a conviction and the nature of the evidence in support of the accusation, this factor was not considered. Yes, had it been before the trial was initiated, that would have been a different aspect. But on the very day, position of these two witnesses have been taken. This was not considered. Now, reasonable apprehension of the witnesses being tampered with on the apprehension of their being a threat so, while it is not expected to have the entire evidence establishing the guilt of the accused beyond reasonable doubt, but there ought at least to be a prima facie satisfaction of the court in support of the charge. Privacy in proceedings should always be considered, and it is only the element of genuineness that shall have to be considered in the matter of grant of bail. Now, what is the question of friability? Because it's a very genuine case so far as prosecution is concerned. It is not a case that Nani Chatu have been implicated falsely or otherwise. That is not the case. Even that is not the case of the defense. The case was simple, 1 year and 2 months. Now, and in the event of there being some doubt as to the genuineness of the prosecution, in the normal course of events, the accused is entitled to an order of bail. That when a doubt is created on the genuineness of the prosecution case, grant of order of bail is entitled. But it is not the case in this. The genuineness of the prosecution case is prima facie established, prima facie. I'm not saying beyond all reasonable doubts, prima facie. And this also said in this. Prima facie established, not beyond all reasonable doubts. But the part of the prosecution, the strong case of the prosecution is that the particular statement, 160 statement by two sisters have not been rebutted. By them, by the sisters. They have admitted the deposition. Proof. Now, in Chamanlal has laid down certain factors, namely the nature of the accusation, severity of the punishment in case of conviction, and the character of supporting evidence. Reasonable apprehension of tampering with a witness so-and-so, and prima facie setting of the court in support of the charge. So these factors, so far the severity of the punishment and the character of supporting evidence have not been considered in this bail order. 3 pages bail order, 1 paragraph, I have perused the record, 1 year, 6 months, yes, but is entitled for bail. That too in 302. Now, para 11, in this context, we may profitably refer the dictum of Prasanth Kumar, where it has been held that normally this court does not interfere with the order passed by the High Court when a bail application is allowed or declined, but the High Court has duty to exercise its discretion cautiously and strictly. Regarding had to be basic principle laid down by this court from time to time, the court enumerated a number of considerations, and some of the considerations which are relevant for the present purpose are whether there is likelihood of the offense being repeated and whether there is danger of justice. That the danger of justice, my lord, the word is danger of justice. So, on this ground, if bail is given in such heinous crime, this is not a danger to the society, it's a danger to the justice. The word is not danger to the society, it's a danger to justice. Danger to society is different. Danger to justice is different. And if bail is granted in such a casual manner, it's a danger to justice. And danger to justice is by grant of bail. That's what Supreme Court said. Now, we have referred to certain principles to be kept in mind while granting bail. It has been laid down by this court from time to time. It is well settled in law that cancellation of bail after it is granted because the accused has misconducted himself or some superseding circumstance warranting such cancellation have occurred. It's a different compartment altogether than order of granting bail, which is unjustified, illegal, and perverse. I'm not on the superseding circumstances that he has misused or abused. If in a case, the relevant factors which should have been taken into consideration while dealing with the application of bail have not been taken note, or bail is founded on irrelevant consideration, that the family members are doing dharna, protest from time to time. This is irrelevant consideration. Indisputably, the Superior Court can set aside order of such grant of bail, such a case belongs to different category, and it's a separate realm. While dealing with a case of second nature, the court does not dwell upon the violation of the condition by the accused or the superseding circumstances that have happened subsequently. On the contrary, delves into the justifiability and the soundness of the order passed by the court. This para 12 is very important because it is segregated parts. One for superseding circumstances, one on the perversity. In the context, two aspects have been highlighted before us: the criminal antecedent of the executive one, and this is so far the accused, the non-applicability of the principles of parity on the foundation that accusation against all accused so and so. First, now, para 16. Para 16. This is so far this case is concerned. Para 16, what that is presented before us is whether this court can annul the order passed by the High Court and curtail the liberty of its second respondent. We are no oblivious of the fact that liberty is a priceless treasure for human being. It is founded on the background of the constitutional para 16, the last para.
Yes.
Constitutional right and accentuated further on the human rights principle. It is basically a natural right. In fact, some regard it's a grammar of life. No one would like to lose his liberty or barter it for all the wealth of the world. People usually have fought for liberty, for absence of liberty causes a sense of emptiness. The sanctity of liberty is the fulcrum of any civilized society. It is cardinal value of which the civilization rests. It cannot be allowed to be paralyzed and embodied. Depriving liberty of a person has enormous impact on his mind as well as body. A democratic body polity which is wedded to the rule of the law anxiously guards liberty. But a pregnant and significant that the liberty of an individual is not absolute. Society, by its collective wisdom through process of law, can withdraw the liberty that it is sanctioned to an individual becomes a danger to the collective and to the societal order. Extent of individual liberty cannot be pyramided to that extent which would bring chaos and anarchy to a society. A society expects responsibility and accountability from its member, and it desires that citizens should obey the law, respecting it as cherished and social norm. No individual can make an attempt to create concavity in the stem of social stream. It is impermissible. Therefore, an individual behaves in a disharmonious manner, ushering in disorderly things which the society disapproves. The legal consequences are bound. At this stage, the court has a duty. It cannot abandon its sacrosanct obligation to pass an order of its own whim and caprice. It has to be guided by the established parameters of law. So, what are the parameters of law that has been dealt again in subsequent ruling? Now, this is what Niru Yadav said about the liberty.
Not finding. Next one is, what is your next one? She will check now.
Deepak Yadav hai. Deepak Yadav. ये just check.
Marked here para 21, 22, 23, 25, 26, 27, 30, and 31.
My lord, Deepak Yadav. I've got extra. My lord, that I have, it was argued in length before Justice Budi Agum. Somehow, when it was passed, judgment was to be delivered on that day itself, he has recused himself. Now, I respectfully take my lord to starting from para 19. The principles governing grant of bail, then my lord will find in page 9.
Yes. Yes, sir.
My lord, section 49 of the CRPC is the guiding principle for adjudicating a regular bail application wherein court takes into consideration several aspects. The jurisdiction to grant bail has to be exercised cautiously on the basis of well-established, well-settled principles having regard to the facts and circumstances of each case. In para so, now, the jurisdiction to grant bail has to be exercised on the basis of well-settled principle having regard to the circumstances of each case and not in an arbitrary manner. While granting the bail, the court has to keep in mind the nature of the accusation, the nature of evidence in support thereof, the severity of punishment which conviction will entail, the character, behavior, means, and standing of the accused, circumstances which are peculiar to the accused, reasonable possible securing presence of the accused at the trial, reasonable apprehension of the witness being tampered with, the larger interest of the so and so. Now, these are all the basically these are all the parameters to be considered. Now, in para 21, just down in the same reason, it says the legislator has used the word reasonable grounds for believing instead of the evidence. At the time of the reasonable grounds for believing instead of evidence. Now, even though there is evidence, let's forget about for a timing that evidence. But what about the reasonable ground? Before the trial starts, it is 164. Once the trial starts, it's deposition. So let's forget about the trial, about the evidence. The reasonable ground for believing that he has committed a crime can be based on a 164 statement. Now, even coming one step further, if we bring the evidence after the two sisters has deposed, the evidence comes into play. That Lord has rightly pointed out the corroboration part. Because I say that it was not rebutted. Unrebutted deposition, we don't need corroboration. Corroboration comes only when that evidence has to be appreciated, reappreciated. That occasion has not arose in this particular case. Now, instead of which means the court dealing with the ground of bail can only satisfy as to whether there is a genuine case against the accused and that the prosecution will be able to produce prima facie evidence in support of the charge. They have done it. Now, as reiterated by the two judges so and so, now this aspect, my lord, I don't need to go again and again that there is a prima facie or reasonable ground to believe that accused had committed offense, nature and gravity of accusation, severity of the punishment. Out of these 7, 1, 2, 3, now They will say that danger of the accused absconding free or release on bail. No, he's still on trial. That part cannot rule. These are all the eraser part is to have to be compartmentalized. 1, 2, 3, and 7. 1, 2, 3, and 7. It is at the time of grant of bail. 4, 5, 6, 7. It is supervening circumstances after the bail is granted. But I am on 1, 2, 3, and 7 on the day when the bail was granted. Because whether a justice was being thwarted by granting the bail, making it a danger to justice. 1, 2, 3, and 7. Now, my lord, 23. In recent pronouncement of this court, in this particular case, it was by Justice Ravana was leading the particular bench when he was CGI. In that para 11, paragraph 23, the excerpt of this para 22 is very important. The impugn order passed by the High Court is cryptic and does not suggest any application of mind. So, my humble submission is on the application of mind with all my respect to the learned session judge. There's no application of mind, and this is a very cryptic order giving 3 grounds. There's a recent trend of passing such orders granting or refusing to grant bail, where the courts make a general observation that the facts and circumstances, I have perused the record. I have perused the record, and the facts and circumstances of the case have been. This is what the Supreme Court has come down very heavily, that this is a very cryptic order and it's total non-application of mind. No specific reasons are indicated which precipitate the passing of the order by the court. Now, if we go by this 3-page order, where in one para he has said, I have perused the record, he's 70 years old, he's entitled for bail. My lord, is it a cryptic? And there's no application of mind. He was even, with all my respect, swayed by the peaceful stays by the family members that Nanni Chatung ko fashi do. Can a judicial officer be swayed by that? Such a situation continues despite now. This cryptic nature of the order passed by the trial court, the Supreme Court has come down very heavily. Such a situation continues despite various judgments of this court, wherein this court has disapproved of such practice. Merely record, it has come exactly like our case, merely recording having perused the record. The ditto word used in this particular bail order, where I see with all my respect, a cryptic order, it says the evidence collected in and the ocular evidence as well so and so that a victim I have given due consideration of the grounds pleaded so and so to be so and so. Now, this having regards to the entirety of the, and this court is considered that over. This is what he said. Nothing on the evidence collected by the evidence collected by the investigator and the ocular evidence as well as documentary evidence, so that, right? I've also given due consideration to the grounds pleaded by the accused as well as he says, he is stated to be 72 and having permanent residence. Having regards to the entirety of the evidence placed on record, this court is of considered view that the accused can be admitted. This is what the Supreme Court, merely recording, having perused the record and on the facts of the circumstance does not serve the purpose of a reasoned judicial order. Now, my whole case is about reasoned judicial order. Reasoned judicial order. Not only an order passed by a learned session judge, I'm on my plea is on a reasoned order. It is a fundamental premise of open justice to which our judicial system is committed that the factors which have weighed in the minor results in the rejection or grant of are recorded in the order passed. Open justice premise on the notion that justice should not be done, but should manifestly and undoubtedly be seen to be done. We have been. Now, judges are duty bound to explain on the bases on which they have arrived at a conclusion. Now, now para 26. Para 26. Recording of reasons for grant of bail by the court of the session court. The importance of assigning reasoning for grant of denial of bail can never be. There is a prima facie need to indicate reasons, particularly in cases of grant of denial, where the accused charged with what? Serious offense. The Honorable Supreme Court, as well as the Honorable High Court, even the learned session judge, so far the cases that comes up to 7 years, when some lenient views have been taken, even though there's a strict directions from the Honorable Supreme Court or Honorable High Court to have a reasoned order, but particularly, but in case of serious offenses, the heinous crime that we say, there's no excuse, there has to be a reasoned order. Now it says where the is charged with the serious offenses, the sound reasoning in a particular case is reassurance that discretion has been exercised by the decision maker after considering all the relevant grounds and by disregarding extraneous consideration. And by disregarding extraneous consideration, this is what Supreme Court has said, adding another word, extraneous consideration. The factors that is extraneous consideration is which is not relevant with the record of the case, maybe with the state of Dharna. That also can come under extraneous. Now, the duty to 27, the duty to record reasons is a significant safeguard which ensures that discretion which is entrusted to court is exercised in a judicious manner. We disapprove of the observation of the High Court in a succession of orders that the present case recording that counsel for the past do not praise for a further reason order, so and so. Reason order. The grant of bail is a matter which implicates the liberty of the accused. Grant of bail is for the liberty of the accused and interest of the state, my lord, it's not only for the liberty of the accused, but it's also for the interest of the state and the interest of the victims of the crime. So first, the liberty of the accused has to be considered. The paramount consideration is not only the liberty of the accused, but it's also the interest of the state and the interest of the victims. If that is required in the proper administration of criminal justice. By taking care of the liberty of the accused, we cannot forego an overall interest of the state as well as the victim. It is well settled principle that in determining as to whether bail should be granted, the High Court or for that matter, the Session Court, deciding an appeal would not launch upon a detailed evaluation of facts on the merits since a criminal trial is still to take place. This observation, while adjudicating bail, would also not be binding on the outcome of the trial, but the court granting bail cannot obviate its duty to apply judicial mind to record reasons, brief as they may be, for the purpose of deciding whether or not to grant bail. Now, grant of bail, next para, the same continuation. Grant of bail under 49 is a matter involving exercise of judicial discretion. Judicial duty is granting or refusing bail is in the case of any other duty which is vested in a court as a judicial is not unstructured. The duty of to record reason is a significant safeguard which ensures that the discretion which is entrusted to the court is exercised in a judicious manner. The recording reasons in a judicial order ensures that thought process underlying the order is subject matter to scrutiny and that meets objective standards of a reason and justice. Therefore, even though bail is granted, even though bail is rejected, the accused has to feel that justice has been done, the victim has to feel that justice has been done. Now, in Ram Govind, that grant of bail, though being a disciplinary order, but however calls for exercises judicial in a judicious manner and not as a matter. Order for bail, bereft of any causal reasons, cannot be sustained. The very reasons, we don't find a very reasons here. Because it's a heinous crime, 302, either life or death. Only two options, convicted, life or death. Needless to record, however, that the grant of bail is dependent upon the contextual facts of the matter being dealt with by the court, and facts, however, do anyways vary from case to case, while placement of the accused in the society, though may be considered, but they itself cannot be a guiding factor in terms of grant of bail, and the same should and ought always be coupled with others warranting the grant of bail. The nature of the offense is one basic consideration for the grant of bail. More heinous a crime, the greater is a chance of rejection of bail. This is what Supreme Court said. The nature of the offense is one of the basic consideration of the grant of bail. More heinous is the crime, the greater is the chance of rejection of bail, though however dependent on the factual matrix of the matter. Now, on a mere procedural record, what is there? Everything is against the accused by his own omission and commission. Now, these are all about the prima facie seminar. And on the last occasion, para 31, the parameter is of the cancellation bail in Doraram, it is also written. Para 31, it is no doubt true that cancellation bail cannot be limited to the occurrence of supervening circumstances. The court certainly has the inherent powers and discretion to cancel bail of any, even in the absence of following. Now, para 31, now I'm not on the supervening circumstance. Soon after the bail was granted, I filed this. So, question of supervening circumstance doesn't arise so far my case is concerned. Or my learned friend may say that he has not misused the liberty. I'm not on that. Because following under where the bail can be cancelled, no supervening circumstance, but still bail can be cancelled, para 31. Now, para 31 says A. Para 31 says where the court Granting bail takes into account irrelevant material of substantial nature and not trivial nature, while ignoring the relevant material on record. So the ground 70 years, the stays, dharna, I was on leave for 6 months, so it could not proceed 1 year and 2 months. The relevant material was not taken into account. What relevant matter? The relevant matter on record on the day when the order was passed. It says relevant material on record. Now, where the court granting bail overlooks the influential position of the accused in complaint to the victim abuse or witness, especially where the misuse of position and power over the victim. He was a police officer. He was in the police department earlier, that's it. Now, where the past criminal record and conduct of the accused is completely ignored while granting bail. So, even the PP has said that there was an incident where he is influenced. Well, may not be on record. Even I'll not go to that line also. But where bail is granted on untenable grounds. Whether this particular perusal of the order passed by the learned session judge, is it tenable? Only on these 3 factors. On 302, where serious discrimination are found in the order granting bail, thereby causing prejudice to justice. If a bail is granted in this nature of heinous crime, where there are clear-cut evidence against the accused, it's not a prejudice caused to the victim. It is not even a prejudice caused to the society. It is a prejudice caused to the justice. That is what Supreme Court wanted to say. When serious discrepancies are found in the order granting bail, thereby causing prejudice to justice. Not a prejudice to victim and not a prejudice to society. A prejudice to justice. Where the grant of bail was not appropriate in the first place, given the very serious nature of the charges against the accused, which this entitles him bail and thus cannot be justified. What are the grounds where he could be granted bail? When the order granting bail is apparently whimsical, capricious, perverse in the facts of the given case. That is how the Supreme Court has heavily come down. Now, another decision. Now, para 33 in this particular adjustment. Now, para 33. But I'll start from para 26. 26, 27, 33. 26. Para 26.
You already dealt with this matter, the relevant parameters for granting bail. In
Yes.
that case, earlier case. it
Yes,
was
yes.
been
yes,
that.
yes. Gravity of the offense, the role
I'll see to it.
attributed. Now, para 27 also. Para 27. It is equally well settled that bail once granted ought not to be cancelled. 26. in a mechanical manner. However, an unreasoned or purpose order of bail is always open to interference by the Supreme Court. If there are serious allegations against him, even if he has not received the bail granted to him, such an order can be cancelled by the same court that was granted the bail. Bail can also be revoked by a Supreme Court if it transferred that courts below have ignored the relevant matter available in the court and not look into the gravity of the offence, the impact of the sentences I have read in that particular judgment. Now, para 33. This is the discussion. Para 33. Furthermore, and most importantly, the High Court has overlooked the period of custody of the respondent accused for such a grave offence alleged to have been committed by them, 303. As per the submission made by the learned counsel for the stay of the plea, before being released on bail, the accused had undergone custody for a period of about 2 years, 4 months. The accused has been for a period of 2 years and 8 months. The accused has been for a period of about 2 years and 9 months, and the accused for a period of 2 years. In other words, this is very important. In other words, all the accused respondents have remained in custody for less than 3 years for such serious offences of double murder for which they have been charged. Now, even the Supreme Court has said, in a murder case, you're counting the days. Well, you have not even undergone 3 years, and you are saying that the length of the detention behind the bar. Here it says 1 year and 2 months. It's such a heinous crime, serious offences. Now, they have interfered. Now, based on the title law, or in the catena of judgment passed by the Honorable Supreme Court and other high courts, if the bail order is perverse, infirm, and where the relevant matter have not been considered, whether bail order can be sustained or not. I say I'm not only supervising circumstances. I'm only specifically on the order passed by the learned session judge. And my lord, in the legi ori case, where lordship has passed this order, even I may not revoke, your lordship has dealt. Your lordship has dealt in a very elaborate manner about all these aspects, but Deepak Yadav has not been dealt here in this case, and the recent one. Now, here, bail was cancelled by your lordship on the ground that same ground where the Supreme Court has gone. So, but I may not even, because I can submit one and lordship knows about that. You'll be killing your judicial time. So, under these facts and circumstances, when this particular bail has been granted, it needs to be cancelled. Because in any manner, the order passed by the session judge cannot sustain in the eyes of the court. I may be allowed to reply after my comment.
Hello. Before I refer the impugn order and whether the relief sought by the petitioner can be granted or not, madam. First, I would like to just reply the particular provision, the judgment decision that rendered, relied upon by my learned friend, man. Just first, the judgment he relied upon is Niru Yadav, 2014-16 SEC. Madam, the factual aspect has to be examined. This was the case where learned trial court has rejected the bail application, having considered all relevant facts. Even the fact that there's as many as 14 cases already registered, charged against the accused person. And considering this aspect, the bail was rejected. And accused approached the High Court. High Court, having not considered, even having not taken into these consideration that as many as even the antecedent
14 case was already registered and charged. This was not taken into consideration, and straight away bail was granted. Against which SLP went, gone to the SLP, and this is how the Honorable Supreme Court has held that well considered, especially when the bail has been rejected by the trial court, while exercising 439, my lord, the Superior Court, Honorable High Court, especially has to consider this aspect, has to justify why the rejection order passed by the learned trial court is illegal. This reasoning has to be given. This is why on this fact, madam, no reference has been made in respect of the rejection order even made by trial court. This is the ground the order has been passed, and this factual aspect, madam, the new case is not applicable in my case. Now, coming to the Deepak Yadav case. Deepak Yadav case is also, this has also been elaborately discussed, my lord. In Deepak Yadav case also, my lord, Deepak Yadav case, I believe my learned friend has supplied the printed copy, but it is reported in SSC already, 2022 8 SSC 559. This is reported, man. Here, my lord,
Is the status correct?
2022 8 SSC 559. 559. Now, here factual aspect is, my lord, what happened? The trial court rejected the bail. Because why trial court rejected? There's ample evidence. It was the case involving Arms Act and 302. Life cartridges were recovered from the accused, and this was discussed by the trial court. And the High Court, against this rejection, they went to the High Court, and High Court granted a bail, enlarged the accused on bail without considering this aspect. Even the recovery, even the life, the cartridge, it was the weapon involved in the offense, country-made weapon that was seized, live cartridge was seized. This was not taken into consideration. That is why this detail how the judgment and granting bail to the accused person is perverse and is illegal. That has been discussed in para 38 to para 38.8, how it is illegal. And the country-made pistol with 2 live cartridges, it was recovered from the accused. It is on the record that para 6 of the Deepak Yadav, this has been mentioned. This is on this background, but the High Court has not taken into these aspects and straight away granted the bail. That is why they went to the SLP, and this fact come out, madam. Now, this is why this is in this background, this Deepak Yadav case has been, judgment has come out, and it is not applicable to my case. It's a factual aspect. Now, again, while dealing with the Deepak Yadav, my learned friend has also referred Prashant Kumar. Prashant Kumar case, my lord, it is already the 2010-14 SSC 496. Prashant Kumar case. This fact is also.
So this Deepak Yadav relied on Prashant Kumar.
Yes, they are referred to in the Prashant Kumar. My learned friend has referred to it, Prashant Kumar case also. The Prashant Kumar, the decision of the Prashant Kumar, but that's a factual background different. In the Prashant Kumar, trial court rejected the bail. The High Court, because there was even in the Prashant Kumar matter, TIP was conducted. In the TIP, the witnesses identified the accused, and according to having considered these aspects, the trial court rejected the bail. Then accused went to the High Court. The High Court, well, admitted granting bail, only 3 lines. Only on 3 lines, accused has been, without discussing any reason, even without making any reference to the bail rejected by the trial court, application rejected trial, without even making reference to, on a 3-line manner, application on 3-line sentence, accused has been enlarged on bail. Again, the SLP went to the SLP and this detailed discussion, at least granting the bail when trial court has been rejected, that bail has been rejected by the trial court, at least that reason should why the Honorable High Court is granting bail, despite the first bail moved before the trial court has been rejected. At least that justification has to be made. But in the present Kumar case, not just even reference has been made against the trial court rejection order. That is why the case, the ratio and decision has come out, man. Now, and as were it is rather in my favor, Malad, supervening factors is there. Now I'll just come to my affidavit, Malad. I filed my affidavit. Respond to have filed affidavit, Malad. Just I'll show the straight away. I'll show the just for my sake, Malad. I'll refer the impugn order, Malad. Malad's page 26 is the impugn order dated 26/2024.
Yes.
Yes. Malad, para 2, Malad, there's already read out, Malad, para 2, Lika Taben shown, Malad. The accused has spent 1 year and 2 months in judicial lockup since his arrest. Submitted the accused person is clean, except being implicated in present case. Mr. So-and-so contends that since the beginning of the investigation, accused has fully cooperated with investigation and he's doing the trial. Now, this is the factual submission made on behalf of the applicant in the trial court. Now, at page 27, I will see. Just I'm reasoning, I'm trying to highlight. Upon hearing the learned counsel on the fact and law, I thoroughly perused the records. Till so prosecution examined witnesses and 2 witnesses stated to be family relatives of the. I've also seen the CFSL reports which indicates that the blood stain found in the weapon of the offense was human being blood group of any person not disclosed in the report. Now, thereafter, my lord, see at page 28. Just to show the reasoning, it is plausible reason, my lord. 28, second paragraph. The evidence collected by the investigator and the ocular evidence as well as documentary evidence shows that the victim died at a homicidal death. I have also given due consideration to the ground pleaded by the accused as well as his age. He is stated to be 72 years of age, having permanent residence at Hong Blaze, so on and so on. Having regard the entirety of the evidence placed on record, this court is of the considered view that accused can be admitted in bail and under following term. Now, this is my respectful submission. It is a reason and plausible reason on the basis of which the London trial court has granted bail. Now, as of now, 8 witnesses has been examined, and on the case record, my lord, there are not a single eyewitness to the incidents. There's no eyewitness at all in the case, and there's no any prima facie case against the alleged accuser. My lord, so far, 161 statement, it is not admissible evidence. So for 164 statement, my lord, it is also not a substantive evidence. It can be used only for corroboration on contradictory, my lord. This has been well settled, my lord. At earlier occasion, as I referred, relied this decision, madam, where it said that the 164 statement is not a substantive evidence. It cannot be used for the purpose of conviction. It can only be used for corroborating or that is when accused comes to the dock and it supporting and corroborate with the evidence, the earlier 164 statement, then it can be, madam, substantive. Otherwise, if it is not corroborating, it cannot be used. Now, this is, my lord, all about, my lord, just brief fact, my lord. Detail I have already highlighted, my lord, in this, my affidavit, that the calculation of the bail, my lord, there's a certain limited scope, my lord, on the having considered merit, if it's been granted, only limited scope is that accused person has misused or treated. That is the one. There's a supervening circumstances. Other part, madam, perversity, it is not here at all, madam. The perversity cannot be, but it is not a ground for perversity. It has been considered on merit. Now, in this regard, madam,
No, he is stressing that he is not stressing on the supervening circumstances. As per him, the bail which was passed, it was a perverse order, and the materials which were placed before him has not been looked into or not considered at the time of passing. That is, the submission supervening is not stretching.
my lord, this part, my lord, there is no such material evidence. Even my affidavit specifically said there's no even entire evidence, my lord, to see the record. There's no material evidence, material eyewitness at all, my lord. There's not a single eyewitness. It's based on presumption and hearsay, my lord. What he's emphasizing is on 164 statement. Now, 164 statement is not a substantive evidence. Now, the person who recorded, whose statement is recorded under 164 now that has come before the trial court and adduced evidence, he said that the content of the statement 164 that is not read over to me. That is the state. There's no corroboration at all. That has been considered, my lord. When if there's an eyewitness implicating, then that could be, but there's no eyewitness, my lord. Entire record, there's no eyewitness, not a single one. Despite there's no prima facie material evidence against the accused person, accused has been in the jail more than 1 year and 72 years age. My lord, this 72 years age, this is the material for a relevant factor for consideration while granting bail by the trial court, my lord. There's a subtle principle of law. I just relied that part also. And this entire document, why I'm saying that, my lord, the record has been called for, my lord, see, not a single eyewitness. The learned trial court has perused the order, perused the entire record. After having perused the entire record, he has applies judicious mind according to this has been passed. But so for 164 statement, it is not a substantive evidence. There's no any eyewitness, single eyewitness. It is on the presumption only. That is why even there's no perversity at all in the order of the learned trial court. My lord, although our last occasion I have submitted the details by citation, but for convenient, my lord, I'll just, it may be, for convenient, I just made a compilation.
It's a compilation.
Yes, for a convenient all. My lord, first, regarding the bail cancellation, I relied as many as 6 cases. The latest is judgment of 20 February 2025, my lord, 6, my lord. Just right from 1995, my lord. This, regarding, my lord, the age factors and having perused the detailed records, my lord, this has considered how the Honorable Supreme Court has dealt with, my lord. My lord, first, my lord, see, first, my lord, Daulat Ram, page 2 onward, page 2. Para 4, and 5. Madam, para 4, rejection of the bail and cancellation is to be treated differently, and those circumstances has to be met, madam, fulfilled for cancellation, madam, as highlighted in para 4 and para 5, madam. Now, I'll just highlight only, and again, Makelia Dram Raj, madam, this case, page 47, madam, see, page 4, relevant paragraph, madam. I just highlighted the relevant paragraphs. It starts from page 4 and 7. Second is start from page 4 and relevant paragraph page, my lord, see at page 6 to 7.
Para 8.
Yes, para 8, my lord. Para 8, my lord, that is elaborately discussed, my lord. Para 8 and para 10. My lord, 10, para 10, my lord, para, this is general principle, para 8. Para 10, my lord, I'll just highlight, it is relevant to the present case, my lord. It is similar to the present case, my lord. Para 10, having perused the law laid down by this court on the scope of the power to be exercised in the matter of cancellation of bail, it is necessary to examine whether the order passed by the session court granting bail is perverse and suffer from infirmity which has resulted in miscarriage of the justice. No doubt, session court did not discuss the material on records in detail, but there's an indication from the order by which the bail was granted that entire material was perused before grant of bail. It is not a case of either the complainant or respondent or the state that the relevant consideration having been taken into account by the session court while granting bail to the appellant. The session court while granting to the appellant cannot be termed as perverse, as the session court has conscious of the fact that investigation has completed and there was no likelihood of appellant tampering with the evidence. Now, paragraph 11 and 12 like this one. The elaborate discussion has been done, my lord. Now, my lord will see next case, my lord, 2022, 15 SSC, my lord, page 8 to 30. Now, relevant paragraph. Now, this is three judge bench, my lord, para 25, 24, my lord, page 25, 24, my lord. Page 24, my lord. As can discern from the above discussion, for cancelling bail once granted, the court must consider whether any supervenient circumstance has arisen or the conduct of the accused so and so. That is in case, my lord. And para 25, my lord, will see ground has been cited on which ground the bail granted can be cancelled, my lord. This is the parameter, my lord. And none of this, in my case, none of these ground falls, my lord. There's no ground that has been made out against any of these ground, my lord. In the present case for warranting cancellation, my lord. Now, again, my lord, see at next fourth citation, my lord. SSC online, 22 SSC online, so and so. Page 31 is start and paragraph page 34 to 35, my lord, 11. My lord, this is with regard to the age factor, my lord. Page 34, my lord, will see in this case. Para 16. Last 3 line, my lord. Further, the fact that appellant is a lady in 55 years age cannot be ignored, particularly when examining the question of grant of regular bail. Page 34, my lord, para 16. But in my case, the old man of 72 years old, and there's no material evidence, eyewitness against the accused person, man. There's no prima facie. Para 19. It remains right that normally very cogent and overwhelming circumstances or ground are required to cancel the bail already granted. Ordinarily, unless a strong case is based on the supervening event is made out, an order granting is not to be order granting bail is not to be likely interfered under so and so. it had been made, so my lord, this same misuse and levered ground that on which the bail can be cancelled. Now, 2024 for SSC, my lord, next is page 37 onward, relevant page 43. Page 43, 11. It is well settled by the Katina of judgment referred by this court that the consideration of grant of bail and cancellation thereof are entirely different. Bail granted to the accused can only be cancelled if the court is satisfied that after having released on bail, the accused person has misused the liberty granted to him, and so on so. Accordingly, paragraph 14, 15, my lord. The bail granted by trial court, cancelled by high court, it has been set aside, my lord. Paragraph 14. Now, last, my lord, this is decided on 20 February 2025, my lord. Page 47 to 50, my lord. Paragraph 10.
There are 20.
Yes. Paragraph 10.
No, decided no.
It is decided on 20 February 2025, my lord. In the index, I have mentioned it. 20 February 2025. This is the recent. Here, Ajwar's case was also dealt with. Page 10, para 10, page 47. 10, 11, 12 also. Considering whether it's to be cancelled or even, there should be no kind of like, the trial should not be held as it is a mini trial, my lord. This para 12 it has been discussed, and 13, my lord. 13, 14, 15. Here also, my lord, trial court having considered a material that granted bail, the high court cancelled, and this cancel was put to challenge, and this is what. Now, consistently, my lord, from since inception till today, my lord, the settled position is as it is that in my favor, my lord. And there's no any prima facie case against me. And this all 161, 164, my lord, is not a substantive evidence. Therefore, my lord, yes, my respectful submission, but no ground has been made out for cancellation of the bail granted by the London trial court, my lord. And alleged accused person, my lord, he is cooperating. There's no instances of misusing also, my lord. This is liberty granted by the London trial court. And as of now, my lord, only 11 witnesses remain to be examined, and only 8 has been already examined, and there's no eyewitness. And one which is they say that one non-ordinarily, that is also not eyewitness, that has already been examined, my lord. This is not the case at all, my lord. There's no case at all. Now, regarding, my lord, he has referred one case, 20 April 2000, my lord's order. That was the case in case of Lige Ori case. My lord, that was the case where my lord has occasion to deal with the cancellation of the bail. The bail was granted by trial court, session court. That too, without considering a very short period time, granted bail, and immediately after granting bail, what happened? Accused threatened the victim, even witness also. This is POCSO, and even he attempted to repeat the same offense. Then the complainant again lodged the subsequent the FIR to the concerned police station. The police officer did not do anything. Then made a complaint to the SP. SP also, there's no any consequences action. And thereafter, my lord, they approached the trial court for cancelling. But trial court, without considering this aspect, has rejected the bail application for cancellation. That is why, my lord, my lord, while considering this aspect, my lord, there's a supervening event, my lord. This is absolutely different. Supervening, having considered that there's a misuse of liberty granted, and despite this fact brought to the trial court has not considered, has not cancelled. That's why, my lord, well, considering the 439(2), my lord, that's cancelled order. And this all together fact is totally different, it's not applicable to my present case. Therefore, my respectful summation in the whole sum, my lord, there's no case for cancellation against the bail granted to the alleged accused person and he's cooperating with the old trial matter. There's no any such complaint. Therefore, there's no case made out. My respect, I mean, let accused person to remain on bail matter because he's cooperating matter. There's no material evidence against. That's what he's saying 164. 164 is not a substantive evidence. My lord, just 164, although I have submitted that regarding 164, citation I've already submitted. It must be there. 2010 6 SCC. Well, this copy is with me. I can also furnish 2010. 2006 730 2010 6 6. It's there. No, let's get this one. 2010 736 page 6 para 6. This regarding my lord, statement recorded one under 164 CRPC cannot be used as substantive evidence except for corroborating and contradicting. And the similar my lord, that's 1998 4 SCC. Para 36. This is also on same footing. 164 statement. I have always para 36 my lord. The elaborate discussion has been made. Therefore, while considering bail application, my lord, there's no prima facie case against the alleged accused person, and there's no material at all. Because 164, my lord, it is to be testified when a witness is called in the witness box, and has to be corroborated, my lord. And when the certain witnesses that is called, they have not corroborated, my lord. They have said that no, 164 statement, the content of what it has been said have not been read over. I don't know what it has been said. They said in the witness box, madam. There's no corroboration at all. Therefore, there's no material evidence against the alleged accused, even as on today, madam. Well, at the time of consideration application also. Therefore, my response submission, madam, there's no illegality on in the order well passed by the London Trial Court granting the alleged accused person on bail, as he has already been spent more than 1 year, and he was the age 72 years old man, madam. And there's no any instances that he has tempered evidence or misused their liberty. Therefore, my response submission, madam, the discretionary power vested upon this once 439, madam, it's not made out, madam, to be excited, madam. My response.
Yes.
Please, your lordship. Lordship, my submission would be in favor of for cancellation of bail, your lordship. And the reason thereby is that the impugn order that has been challenged, your lordship, the ground put forward by the accused was 2 grounds. That is that there is an incarceration of 1 year 2 months, and the second is that he is an age-old man. Otherwise, there was no any other ground when the bail application was filed, your lordship. Now, if your lordship has already gone through, your lordship will see the PP has already apprised the court about that the accused was a retired person and he had shown his influence in the past during the, your lordship, when the case was registered, your lordship. Now, if this point was also brought to the court's notice, the subsequent point that was brought to court notice was that there was one eyewitness, and since the accused had already shown his influence in the past, your lordship, there is an apprehension that he might also be intimidated, your lordship.
That the person from Arunachal.
He's not from Arunachal. He's not an Arunachali, and therefore there might be.
No, one matter is that a person from Arunachal, there may be a evidence may be tempered with from a.
Yes, he's not. The one of the eyewitness is not, which was not examined at that point of time, was not an Arunachali. Meaning thereby, I'll just Meaning that, but since he is not a local person from the state, there is an apprehension that the accused being a local and already a police officer, a retired police officer, there is high chance that he might influence him, Your Lordship.
Just sorry for disturbance. Madam, that pronoun or naturally, but they have been examined and depositions. But even he did not recognize it, madam.
Yes.
Just
Now-
two deposition, madam.
No, this is the, as per.
Subsequent.
This is the eyewitness.
Yes, eyewitness, which they are saying this eyewitness. Eyewitness, madam.
No, the person who is stated to be.
Yes, yes, yes.
Actually, one, this one.
Yes.
Now, if I may, Your Lordship.
He has already
No.
examined and say that I did not recognize this person.
Your Lordship.
Yes.
Now Your Lordship will also see at page number 16 of the impugn order that the Honorable Trial Court has also taken into consideration that only 3 of the witnesses who are the family members of the accused was examined, and 27 other witnesses were to be examined, Your Lordship. Out of the 27, only 3 of the witnesses were examined, Your Lordship. That also was taken into consideration. However, while granting bail, Your Lordship, the evidence collected, the ocular evidence, documentary evidence, and all the other evidences were considered. However, the only reason that was given in the bail was that he is a person of 72 years old and he is a resident of the jurisdiction of that particular court. There is no other reason given, Your Lordship. Now, Your Lordship is well aware that Apex on many occasions has stated, if a bail is granted, Your Lordship, a bail granted has to assign a reason for granting a bail, and any bail order without assigning any reason per se is bad in law, Your Lordship. Now, when this matter was called up, Your Lordship, only a specific court record was called for from the trial court. Why? Because only the evidences and only the proceedings and all the documents that was in the court when this bail was granted is only to be considered by this court while deciding this present application. And therefore, the subsequent event, because there was no stay, subsequent examination of any other witnesses also to be not considered, and only those which was there in the record during consideration of this application is to be taken into consideration. Now, Your Lordship, though many citation has been put forward, I too have 1-2 citation, Your Lordship. Your Lordship will see that under 164, the family member whosoever was, 3 of the family members were examined, and they have stated that there was an extrajudicial confession by the accused. Subsequently, deposition was taken on 14/6/2023, and one of the deposition was taken on 14/6/2024, Your Lordship. Now, in their deposition, they does not deny that they were never produced before the magistrate. They admit to the fact that they were produced before the magistrate and they have given their statement. Now, these are 164, 161, as well as the deposition has to be, if there is a collaboration or contradiction, is not part of a bail consideration. It is a part of the trial for conviction or for acquittal, Your Lordship. Now, I was, since the only 2 reasons given was the age as well as he is the resident of that particular jurisdiction, the citation relied by the counsel for the private respondent. In that particular case, Your Lordship, it was a lady who was considered to be 55 years and she was granted bail, Your Lordship. The Apex Court on several of the occasions has clearly stated that ground of incarceration as well as for consideration of bail in regard to lady as well as child below 16 years is to be in a very lenient manner. This is not a case of a woman, Your Lordship. In that particular case also, the taken for age was that because she was a woman. Now, if I may produce this, the citation of Apex Court, Your Lordship, I would like to rely only at paragraph 14. This is 2022 3 SSC 501. Paragraph 14, Your Lordship will see down below page number 5 given, Your
This
Lordship.
one is 2023,
2022, Your Lordship.
2022. And?
3 SCC 501.
Just repeat 2022.
Uh,
2022.
3 SCC 501. It is Manoj Kumar Kokhar.
No, it is
Versus-
there, but this citation I just want.
Yes, Your Lordship. Your Lordship, I would like to rely, down below is the page number, paragraph 14 and 15, Your Lordship. 14 speaks about all the citation that has been relied in this particular case with regard to cancellation of the bail, Your Lordship. However, I would read upon paragraph 15, Your Lordship will find in page number 9. Down below is the page number, Your Lordship.
Yes.
If I may, Your Lordship. On the aspect of duty to accord reasons for a decision arrived at by a court, or for that matter, even a quasi-judicial authority, it would be useful to refer to a judgment of this court in Kranti Association Private Limited and others versus Masood Ahmad Khan and others. So and so. When and after referring to a number of judgments, this court summarized at paragraph 47, the law on the point. The relevant principle for the purpose of this case are extracted as under. Insistence on record reason is meant to serve the wider principle of justice. The justice must not only be done, it must also appears to be done as well. The recording of reasons also operate as a valid restraint on any possible arbitrary exercise of judicial and quasi-judicial or even administrative power. Reasons assure that discretion has been exercised. So all this point that has been relied upon, Your Lordship, is more particularly that when a bail is granted, a reason has to be assigned, Your Lordship. At paragraph 617, Your Lordship will see, if I may read, Your Lordship, we have extracted the relevant portion of the impugned order above. At the outset, we observed that the extract portions are only portion forming part of the reasoning of the High Court while granting bail. As noted from the aforesaid judgments, it is necessary for the court to give elaborate reason while granting bail, particularly when the case is at the initial stage, and the allegations of offense by the accused should not have been crystallized as such. There cannot be elaborate detail recorded to give an impression that the case is on one that would result in a conviction or by contrast in an acquittal while passing an order on an application for granted bail. However, the court deciding a bail application cannot completely diverse its decision from the materials aspect of the case, such as the allegations made against the accused, severity of the punishment if the allegations are proved beyond reasonable doubt and would result in a conviction, reasonable apprehension of the witness being influenced by the accused, tampering of the evidence, the frivolity in the case of the prosecution, criminal antecedents of the accused, and a prima facie satisfaction of the court. So these are the factors that has to be considered, Your Lordship. The second citation has already been submitted by my this second was has already been submitted by the Lordship, this is 2002. 2002 3 SSC 598. I won't read the entire this, Your Lordship. Would like to rely only upon paragraph number 3 and 4, Your Lordship. If I may read, Your Lordship. Grant of bail through being a discretionary order, but calls for exercise of such a discretionary in a judicious manner and then not as a matter of course. Order of bail be free of any cogent reason cannot sustain. Needless to record, however, that the grant of bail is dependent upon the contextual facts of the matter being dealt with by the courts, and facts, however, do always vary from case to case. While placement of the accused in the society, though may be considered, but that by itself cannot be a guiding factor in the matter of grant of bail, and same should and ought always be coupled with other circumstances warranting the grant of bail. The nature of offense is one of the basic consideration for grant of bail. More heinous crime, the greater is the chance of rejection of bail, though however depend on the factual matrix of the matter. 4. Apart from the above, certain other which may be attributed to be relevant consideration may also be noted at this juncture, though, however, the same are only illustrative and not exhaustively, neither there can be any. The consideration being, while granting bail, the court has to keep in mind not only the nature of acquisition, but the severity of the punishment. If the acquisitions entail a conviction and the nature of evidence in support of the acquisitions, reasonable apprehension of the witness being tempered. Now, these are the 4 points that has to be considered. At paragraph 3, the court is very clear with regard that there has to be a reason, and a bail without any reason can sustain, Your Lordship. Also, that Your Lordship, that Your Lordship, the citation that was placed, Your Lordship has passed an order. Yes. That case, Your Lordship. I was also of the PP in that matter, Your Lordship. I'll just clarify, Your Lordship. As submitted, it's submitted by the Learned Counsel, Your Lordship. In that particular matter, what has happened was a bail was granted on 18/7/2023, Your Lordship. Subsequent after bail, there was an influence made by the accused to the victim, Your Lordship. And that complaint was made before the trial court. The trial court did not entertain the application. And they had also complained before the police. Now, in this particular case, Your Lordship, why is this case relevant? Because the first order when the bail was granted was challenged, not the subsequent influence of the victim or the subsequent order of court not entertaining the application for cancellation. This was a fresh application before this honorable court challenging the very first order, Your Lordship. And therefore, even in this citation, this case, this relevant citation, Your Lordship, my humble reliance would be from paragraph 16 to paragraph 23, Your Lordship. This citation is 2024-0 Supreme Guwahati 11. I would like to rely upon 18. So the submission made that this is a complete different case, is not the right submission, Your Lordship. This, in fact, is very much as the same reason, because in this bail application, the permanent resident of Alo, and there is no chance that he will abscond. Even in the present case, the only reason given was that he is a resident of that particular jurisdiction and that he was 75 years. Any cogent reason was given for granting of the bail, Your Lordship. Whereas already all those elements for not considering the bail was also put forward, which is also reflected in the order, Your Lordship. My humble submission.
Just one clarification, just Ori's case, para 3 and 4, that will clear all fact, There are 3 and 4. They discuss about the factual aspect, This was the case supervening circumstances, Supervening. After granting bail, he misused. This was there. There are 3 and 4. The fact on these factual background. This is supervening.
Just 1 minute. Sorry. Just 1 minute. Okay, I have heard you like for more than 2 hours.
No. Whatever my learned friend has cited, all these cases are all on supervening circumstances, number 1. Number 2, the whole case factor, my lord. At least woman gets that liberty, but man doesn't get. That must happen. So it's a very fit case where my petition has to be allowed and the balance needs to be kept.
It may not be possible for me to get the order by tomorrow, because tomorrow I'm leaving a bit. Keeping the order in reserve. If it is possible, then I'll pass the order, deliver the order tomorrow itself, if it is possible. In that case, you may join us through VC also.
Your Lordship, in that case, should I give, because I had two citation which I did not wanted to place before Your Lordship. One is Kalyan Chandra Surana with regard to incarceration, and other is Muniappa. I'll just write a book, list of books.
Okay, that's good. But the one thing is that I'll try to dictate the case by today itself. I'm trying. If it is possible, then I may get it by tomorrow also. But if it not be possible, then maybe Monday, Tuesday or Wednesday. In that case, the order may be delivered through BC also from principal section. I just to reserve for dinner. Hard to. Okay. Fix कर देगा नहीं कि ट्रेन हेयरिंग को बुलाओ लेकिन फिक्स कर देगा नहीं अब बुलाओ
Item number. Item number.
Yes, you have received the, well, this is a charge sheeted one or not yet? Is it a charge sheeted?
Charge sheeted. And earlier occasion, TCR was called for, but as per office note, TCR not yet received.
What nature of case this one? NDPS or POXO? And the other side?
Please, Your Lordship. Your Lordship, this is a bail application for release of accused Asadul Ali. He has been in judicial custody for more than 20 days due to the non-appearance during the trial. Your Lordship.
Due to non-appearance.
Yes.
He failed to appear.
Your Lordship, on
Otherwise, it's a charge sheeted case.
yes, charge sheet. Lordship, on last occasion, this honorable court has observed that the CC has not been done. Therefore, and it was pending for a long time. Therefore, this honorable court has stated that let the CC completion of the CC, then only this matter will be taken up. So, CC has been done, Your Lordship.
From where you're saying they were observation were there after completion of the CC?
The matter was fixed on 12 of this month, Your Lordship.
When?
Today, matter was fixed, supposed to be fixed for hearing of the bail. And Lordship, the CC has been done, Your Lordship. What happened in this case? The IO has submitted the charge sheet on 31st of May 2023, Your Lordship. And the
That is 21B, 27 capital A and 29.
yes.
You have received, who is looking up this one case? Jeannie, you are taking this case? Bail,
My friend El Hagi was is in this matter, Your Lordship.
who is taking?
El Hagi.
She is not here. Anyway, and so it was fixed, whether it was fixed for any TCR is not yet received is here only. As reflected from the 11.3 note, TCR not yet received. It will be required, I think.
No, Your Lordship, because
No,
because Your Lordship, I enclosed a copy of the charge sheet and
no, that I
all
don't
the
know, but
relevant
TCR was
photos are
called
also
for.
annexed.
From record I'm saying TCR was called for, so it has not been received. Let the matter be listed on Tuesday, I think.
Short.
If TCI is already here, then matter may be heard. List of Tuesday. List of the matters will be adjourned. Rest of the matters will be adjourned. There are some 2, 3, 4 additional matters are also here, hearing matters. Due to paucity of time, that could not be taken.
I have seen item 16. That may be fixed for hearing Because the service report in respect of respondent to is completed, paper book has been prepared, I have received it. It won't take much time.
It is a, otherwise it is an order.
Yes.
Can be listed for hearing.
Yes, because we have received the paper book, service is also complete in respect of respondent to.
In this letter, I was confused with it.
Oh.
I have
Here already service completed, paper book received.
So you are appearing for the respond number 2.
No, I'm for the.
Legal aid counsel is the appellant.
Legal aid counsel appellant.
So respondent number 2, anyone is appearing? No.
No, but
Now
report
whether-
reflects that it's been completed. The service-
What nature of case this one?
Legal aid may be provided.
Also case. What I'm saying is even if it's listed on another day, it won't, I mean. It will.
This is the counsel. Website, services completed, no?
Yes. There is a little message. And we have also received the paper book.
It is 8 box.
Yes.
Hardimus and Langen, they learned it legal aid counsel for the appellant. We also heard Mr. G. Tavi, they learned it additional duty appearing on behalf of state respondent. From the office note that it can be presented, it is seen that the service is already completed on respondent number 2. However, no one has represented. Accordingly, the registry is hereby directed to appoint an amicus to represent the respondent number 2. Further, it is submitted by Ms. Dungan that they have also received the paper book, copy of the paper book, and cases accordingly ready for hearing. Next one, the next matter in the hearing column. After 2 weeks will do?
3 weeks because
Okay.
they may need to
List
take
after-
time.
Yes, list after 3 weeks. In the hearing column, it will be listed.
Yes. All right.
If interim is there, your lordship. In item number 12, your lordship, interim is there. So interim may be.
Item number 12, now you're saying item number 12, where from?
Item number, yes, your lordship.
Item number 12?
Yes. Yes, 12. Oh.
You note down pointer, interim was there. Because paucity of time, we are not going to the matter. So if interim is there, that will be extended. We are recording now. In item number 12, interim be extended. We are extending the interim. We will be, interim will be extended.
Okay.
Oh,
Up to 3, otherwise, your lordship, matter may be fixed.
next after 3 weeks. Okay. Okay, take the date now.